As far as modes of transport are concerned, civil aviation has been the fastest growing and the most technically innovative of them all. From the first attempts at powered manned flight to regular spaceflight, we have only just exceeded 100 years of aviation. What is incredible is that the first scheduled international air service was started in 1919. It is probably no coincidence, therefore, that the first International Conference on Civil Aviation took place in 1919 in Paris. Since then, the field of our chosen profession has been subjected to far more international legislation and international agreements than any other profession. The overriding need, which is recognised by all, regardless of political inclination, is for higher and higher safety standards. The degree of international cooperation in this respect is outstanding, and shows that where there is genuine desire to achieve international agreement, it can be forthcoming. After the Second World War and the huge technological advances that were made in aviation, the world at peace sought the solutions to the huge legal and economic concerns that confronted them. There was the question of commercial rights, the legality of overflights of other nations' airspace, and the maintenance and development of navigation equipment, often placed in sparsely populated parts of the world. For these reasons, the United States of America conducted exploratory discussions with the Allied nations during the early months of 1944 to seek solutions to these challenges. Subsequently, invitations were sent out to 55 Allied and neutral states to meet in Chicago in November 1944. For 5 weeks, the delegates of the 54 states who attended considered the problems of international civil air travel. At the end of the conference, a Convention on International Civil Aviation was signed by 52 of the 54 attending states. This convention is more commonly referred to as the Chicago Convention. The Chicago Convention set up the permanent International Civil Aviation Organization, known as ICAO, as the means to secure international cooperation and attain the highest possible degree of uniformity in the regulations, standards and procedures regarding civil aviation matters. At the same time, the International Services Transit Agreement and the International Air Transport Agreement were signed, but you will learn about these agreements later. The 52 states who agreed to the convention would foster the development of international civil aviation to help create and preserve friendship and understanding amongst the world's people, so as to prevent its abuse becoming a threat to world security and promoting cooperation between all peoples of the world. At present, there are now over 180 contracting states to the Chicago Convention, which is up to Edition 9. The Chicago Convention consists of 96 articles and accepts the principle that every state has complete and exclusive sovereignty over the airspace above its territory. It also provides that no scheduled international air service may operate over or into the territory of a contracting state without the state's previous consent. It also establishes the privileges and restrictions of all contracting states to provide for the adoption of the international standards and recommended practices, called SARPs, and these are for the regulation of air navigation, the installation of navigational facilities by contracting states, and the facilitation of air transport by the reduction of customs and immigration formalities. Again, you will study these in more detail in subsequent lessons. The application of any national law is only applicable to the territory over which the state has jurisdiction. In aviation, the extent of that jurisdiction is limited by the horizontal limits of the national territory, but unlimited vertically. The early international maritime rights enabled nation sea traffic to ply the high seas for the purposes of movement. At the outset of commercial flying, similar rights of free aviation operations over the high seas were embodied in the Geneva Convention. The Chicago Convention went on to specifically embody the rights of contracting nations' aircraft to fly over the high seas and territory of another contracting state for the purposes of civil aviation. So we can see that territory, in aviation terms, applies to the airspace existing over the defined limits of a nation's boundary at ground level. Sovereignty is the right of a contracting state to impose its national law upon users of its territorial airspace. Suzerainty refers to the concept of nations accepting the rules and regulations agreed by common consent at international conventions, where there is no requirement in national law of those nations concerned to adopt those rules and regulations. The attendees of the Chicago Convention attached great importance to the question of commercial rights in international civil aviation, and agreed to grant each other certain rights regarding the commercial exploitation of civil aviation. These rights are known as the freedoms of the air, and give the right to transit the airspace of contracting states to scheduled flights. We will cover these freedoms of the air in more detail later on. Not all of the 52 signatories that were on the original Chicago Convention were able to reach agreement about all the aspects concerning this issue, but 2 bilateral agreements were set up. The International Air Services Transit Agreement provides for aircraft of signatory states to fly over or land for technical reasons in the territory of another signatory state, and the International Air Transport Agreement concerns the carriage of traffic between the state of registry and any other signatory state. A scheduled flight is a flight for which agreement has been reached between states at government level. It will concern a schedule and will detail the aerodrome, the number of flights, the period allowed for the flights to take place, and the reciprocal arrangements that have been agreed. Non-scheduled flights are those flights to which no schedule is attached. For example, one-off or charter flights that are flown on an unregular basis. It is part of the convention that signatories cannot refuse such flights on political or economic grounds. Another expression you will come across is cabotage. Cabotage is when an airline wishes to operate domestically within a state other than its state of registry. The EU, for example, applies the cabotage rule to the route between Berlin and Paris. That is, as far as non-EU carriers are concerned, the flight is deemed domestic, not international, and so they cannot operate it commercially. Additionally, in accepting ICAO contracting status, a state, for example State A, agrees not to enter into an agreement with another contracting state, for example State B, to allow State B exclusive rights of the internal scheduled operations of State A. Under international law, states are permitted to impose customs tariffs and prohibit the importation of prescribed articles. In order to allow contracting states to maintain such customs regulations, international flights are required to make the first point of landing in a contracting state at a recognized international airport, which provides both customs and health and immigration facilities. The specifics of these rules will be dealt with later on in the section concerning facilitation. In becoming an ICAO contracting state, a state agrees to observe the international standards specified by the ICAO. Don't forget that it is from these standards that the international rules and regulations governing civil aviation are drawn, and thus each state accepts the responsibility to enforce these rules and regulations within its sovereign territory and airspace by its own national laws. Article 38 of the Chicago Convention requires that each contracting state notify the ICAO of any differences between their own national regulations and the international standards that ICAO has adopted. Thus, a situation is recognized where national legislation and regulation have precedent over international rules within the territorial airspace of that state. Where flights are conducted over the high seas, international rules apply without exception. The ICAO rules of the air are promulgated to standardize the procedures for civil aviation, specifically for the safety of aircrew and passengers. Rules to expedite the safe flow of air traffic are established by the adoption of standards and recommended practices, or SARPs as they are called. Where an aviation offence is believed to have been committed in an aeroplane contrary to the international law, the state in whose airspace the offence has taken place has the right to try and punish the offenders. If the offence has taken place over the high seas, the state of registry of the aeroplane has the right to try and prosecute the offenders. It should be noted that the international agreements oblige states to prosecute in such circumstances. But if a state decides not to, for whatever reason, then any other state may choose to do so. In accepting contracting state status, each member state accepts that it has a responsibility to establish a 24-hour search and rescue (SAR) organisation suitable to deal with the number of civil flights taking place within its own territorial airspace. Contracting state should provide at least the minimum service compatible with the type and frequency of the air traffic using the airspace for which the state is responsible. And that service is to be available 24 hours a day. The requirement also imposes upon the state the need to maintain a degree of cooperation with adjacent states, and the readiness to assist with SAR operations if requested. In this lesson, we will examine the duties of the ICAO member states. You will recall that the aims of the Convention on International Aviation, and thus the aims of the ICAO, are to ensure the safety, regularity and efficiency of international civil aviation operations. Therefore, the primary duty of each member state is to achieve these aims. However, these aims are achieved by ensuring that member states comply with the standards and recommended practices that have been issued by the Air Navigation Commission. For completeness, we will define what is meant by a standard and a recommended practice. A standard is anything which is considered necessary for the safe regularity of international aviation, and to which contracting states will conform, whereas a recommended practice is anything which is considered desirable, as opposed to necessary, for the safe regularity of international aviation, and to which contracting states will endeavour to conform, as opposed to will conform to. The 18 annexes to the Convention contain the standards and recommended practices, and were established after the initial consultation with the contracting states. The standards are considered binding on the contracting states. However, if a state wishes to opt out of any particular standard, it may do so, as long as it informs ICAO, who in turn will publish the non-adherence as a difference. This difference must also be published by the opt-out state in its own Aeronautical Information Publication, or AIP. Although the general duty of ICAO member states is to comply with the accepted standards and practices, there are a few particular duties that are worthy of mention here. You will recall that some of the original aims of the ICAO were to also further the aims of free trade, and expedite the movement of international travellers. States have remained free to impose their own controls on these aspects of air operations. But the ICAO has laid down some governing principles that contracting states should adopt when establishing international airports. These measures are designed to help expedite and encourage civil aviation. The ICAO has extensively studied the issues surrounding taxation, and requires contracting states to follow its recommendations. States are asked to exempt fuel, lubricants, and other technical consumables taken on an aircraft in a state other than the state of registry, providing the consumables are for consumption in flight. They are also asked to undertake the expeditious passage of aircraft, crews, passengers and cargo, especially in the areas of immigration, quarantine, customs and clearance. Within the areas of custom duty and excise charges, the Convention also asks states to reduce or eliminate the taxation of profit or income from air transport enterprises. Annex 9 of the Convention requires states to implement procedures that allows for expeditious handling of goods and cargo intended for import or onward transmission. The establishment of free zones is encouraged. Arriving aircraft departing or crossing the territory of another state will be admitted temporarily free of duty. The privilege, however, does not apply to anything taken off an aircraft, except for spare parts for other aircraft from another state. There are a few more duties of the ICAO member states that need to be mentioned here. The first of these requires that all contracting states apply standard procedures for the registration of aircraft. All aircraft are required to be registered, and the standard identifies the format of registration marks and the nationality symbols, including where they are to be displayed on aircraft. These registration standards are found in Annex 7 and will be dealt with in further lessons. Similarly, with aircraft registration, states are also duty-bound to ensure that all registered aircraft are airworthy and are issued with a certificate of airworthiness. Annex A to the Convention deals with the airworthiness of aircraft. Again, you will study this in a later lesson. In the same manner that aircraft are fit to fly, member states must ensure that aircrew have had the training and are issued with standard licenses. Annex 1 of the Convention deals with personnel and licensing, including flight crew, air traffic controllers, and aircraft engineers. Another specific duty worthy of mention in this lesson is the duty of member states to comply with the standards for the safe carriage of dangerous cargo. Annex 18 of the Chicago Convention details extensively the technical instructions surrounding this activity. Finally, member states are also duty-bound to specify what documentation is to be carried on a commercial flight. Documentation must include certificate of airworthiness, flight crew licenses, load sheets, and maintenance documentation. This completes the lesson on the main duties of the ICAO member states. Remember that essentially the duties of the member states are to comply with the standards and recommended practices set out in the Annex to the Convention. Let's now take a closer look at the International Civil Aviation Organization itself. As we said at the beginning in an earlier lesson, the ICAO, created by the Chicago Convention, is an intergovernmental organization which has become a special agency related closely to the United Nations. Based in Montreal, it provides the machinery to achieve standardization between contracting states for all technical, economic, and legal aspects of international aviation. The aims and objectives of the ICAO are to develop the principles and techniques of international air navigation and to foster the planning and development of international air transportation so as to ensure the safe and orderly growth of international civil aviation throughout the globe, encourage the arts of aircraft design and operation, encourage the development of airways, airports and air navigation facilities, meet the need for safe, regular, efficient and economical air transport, prevent waste caused by unnecessary competition, ensure the rights of contracting states are fully respected, avoid discrimination between contracting states, promote safety of flight in international airspace, and generally promote all aspects of international civil aviation. The Assembly is the complete and sovereign body of the ICAO. It meets at least every 3 years and is convened by the Council. Each contracting state is entitled to 1 vote, and decisions are made by majority vote. Its major tasks include setting the policies for ICAO, as well as electing the members of its working group, the Council. The Council is the permanent body of the organisation and is responsible to the Assembly. It is composed of 33 members of the contracting states, selected by the Assembly for a 3-year term. The Council is the governing body of the ICAO. Standing commissions and committees are composed of members appointed by the Council through nominations from contracting states or elected by Council members. These various commissions are the Air Navigation Commission, the Air Transport Commission, the Legal Commission, the the Commission on Joint Support of Air Navigation Services, the Personnel Committee, the Finance Committee, and the Committee on Unlawful Interference. The ICAO Secretariat is divided into sections, each corresponding to a committee with the role of supplying technical and administrative aid to the Council. It is headed by a Secretary-General, who is appointed by the Council, and is divided into 5 main divisions: the Air Navigation Bureau, the Air Transport Bureau, the Technical Cooperation Bureau, the Legal Bureau, and the Bureau of Administration and Services. The ICAO maintains 7 regional offices, and they are located in Bangkok, Cairo, Dakar, Lima, Mexico City, Nairobi, and Paris. Each regional office is accredited with looking after a group of accredited states, which make up 9 regions, and they are responsible for maintaining, encouraging, assisting, expediting, and following up the implementation of air navigation plans. These 9 regions are the Africa-Indian Ocean AFI region, the Asia ASIA region, the Caribbean CAR region, the European EUR region, the Middle East MID region, the North American NAM region, the North Atlantic NAT region, the Pacific PAC region, and the South American SAM region. The need for regional structure has increasingly become apparent to facilitate the planning of facilities and services, the formulation of supplementary procedures to support increases in air traffic density, the creation of new air routes, and the introduction of new types of aircraft. Regional air navigation meetings are organised periodically to consider the requirements of air operations within specific geographical areas. The idea is to enable integrated and efficient systems across the geographical area and contribute to the global plan. Financial assistance is provided to assist states in specific circumstances. These might be to provide for necessary facilities to be constructed in a country that would ordinarily incur disproportionate expenditure to the gross national product of that state. Such facilities could be navigational aids, instrument approaches, and so on. One of the major functions of the ICAO is to gain adoption of the international standards and recommended practices, SARPs, and incorporate these as annexes to the Convention on International Civil Aviation. There are now 18 of these annexes listed in the 1944 Convention, and they are constantly under review. This is to ensure that they remain relevant and applicable to modern-day civil aviation. You are required to be able to identify the ICAO annexes and their content. The 18 annexes are Annex 1, Personnel Licensing, Annex 2, Rules of the Air, Annex 3, Meteorological Services for International Air Navigation, Annex 4, Aeronautical Charts, Annex 5, Units of Measurement to be used in air and ground operations, Annex 6, Operation of Aircraft, Annex 7, Aircraft Nationality and Registration Marks, Annex 8, Airworthiness of Aircraft, Annex 9, Facilitation, Annex 10, Aeronautical Telecommunications, Annex 11, Air Traffic Services, Annex 12, Search and Rescue, Annex 13, Aircraft Accident Investigations, Annex 14, Aerodromes, Annex 15, Aeronautical Information Services, Annex 16, Environmental Protection, Annex 17, Security, Safeguarding International Aviation Against Acts of Unlawful Interference, and Annex 18, the safe transport of dangerous goods by air. In addition to these annexes, there are some other ICAO policy documents you must be aware of. Firstly, PANS OBS, Document 8168, the Procedures for Air Navigation and Aircraft Operations, or PANS OBS Document 8168, is a two-part publication. Volume 1 describes the operational procedures for air navigation, or PANS, that are recommended for the guidance of flight operations personnel. Volume 2 describes the procedures for the guidance of specialist personnel designing instrument flight charts in geographic areas requiring essential obstacle clearance. Secondly, PANS ATM, Document 4444, the Procedures for Air Navigation Air Traffic Management, or PANS ATM Document 4444, gives guidance to air traffic organisations on the procedures to use when controlling global international air traffic. And finally, the Regional Supplementary Procedures, Document 70304. This document has been developed to enable any geographic, regional air navigational differences to procedures to be recorded. This would normally be done by the ICAO regional offices and approved by the Council. It should be noted that PANS are approved by the ICAO Council, whereas SARPs are adopted by the ICAO Council. The ICAO also publishes a wide variety of publications in the forms of circulars, pamphlets, manuals, and the ICAO Journal, which cover technical, economic, and legal subjects. It also issues training manuals, films, plans, and digests, all designed to inform the global aviation community. Here is a list again of the annexes and their titles, and the procedures documents that you must know to help you remember them. Two other important documents have been developed to accommodate the ICAO's desire to facilitate the exchange of commercial air transport rights. Not all signatories were originally able to agree to this desire, so two supplementary documents were created. These two supplementary agreements establish important international aviation. The first agreement, the International Air Services Transit Agreement, makes provision for aircraft of any participating state to fly over or land for technical reasons in the territory of any other participating state. The second agreement, the International Air Transport Agreement, further provided for the carriage of traffic between the state of registry of an aircraft and any other participating state. These two agreements establish 5 important freedoms, and in the remainder of this lesson we will examine the two documents in detail, and in particular the freedoms that are associated with them. The first agreement to discuss is the International Air Services Transit Agreement. The International Air Services Transit Agreement establishes two very important freedoms of the air. These first two freedoms are the first two of 5 freedoms, which together form the technical freedoms. In this context, the word freedom refers to a privilege conferred by virtue of a bilateral agreement. The very first freedom is a freedom to fly across the territory of another participating state without landing. The second freedom allows for a privilege to land in another participating state for non-traffic purposes, like refueling or repairing, but not for the uplift or discharge of passengers, cargo, or mail. The International Air Transport Agreement establishes the third, fourth, and fifth freedoms, collectively known as the commercial freedoms. The third freedom provides for putting down in a signatory state passengers, mail, and cargo taken on in the state of registry. The fourth freedom provides the privilege to take on in one state passengers, mail, and cargo destined for the state in which the airline is registered. The fifth freedom provides for an airline registered in one state and en route to or from that state to take on passengers, mail and cargo in a second state and put them down in a third state. Due to the growth in air transport and the evolution of airlines operating on a global basis in partnerships, further commercial freedoms have evolved. The modern freedoms provide the 6th, 7th, 8th and 9th freedoms. The 6th freedom provides the privilege for an airline registered in one state to take on passengers, mail and cargo in a second state, transport them via the state of registry, and put them down in a third participating state. The 7th freedom provides for an airline registered in one participating state to take on passengers, mail and cargo in a second participating state, and put them down in any other participating state, without the journey originating, stopping or terminating in the state of registry. The 8th freedom operates within the European Union and allows European Union states the ability to operate amongst the states of the European Union without constraint, no matter the state of registry. In effect, it allows cabotage. The 9th and final freedom was created as a direct result of a conference in Kuala Lumpur that allowed booking code sharing between airline operators. This allows a scheduled flight operator to fly passengers, mail and cargo on a route that has been allocated to another operator or one that is shared by other operators. Unlike the first 5 freedoms, freedoms 6 to 9 are informal in nature. That is, they are not the consequence of any formal international agreement. A number of security-related conventions and protocols have come into being to deal with the increasing global air transport security risks. 3 conventions and a supplementary protocol exist that institute measures to increase the security of air travel. Over the years, they have been enhanced, and the 3 now form the basis of the ICAO security regulation. The Tokyo Convention of 1963 provides that the state of registry of an aircraft is competent to exercise jurisdiction over offences and acts committed on board signatory aircraft. In the case of an anticipated or actual unlawful seizure of an aircraft in flight by a person on board, then all states party to the convention are obliged to take all appropriate measures to restore and preserve control of the aircraft to its lawful commander. After a series of hijackings in the 1960s, the international community, under the auspices of ICAO, resolved to deter and suppress such terrorist acts. The Hague Convention of 1970 ensures that any such act should not go unpunished, and it defines the act of unlawful seizure of aircraft. The Montreal Convention of 1971 further amplified unlawful acts against the safety of civil aviation, and specifies those acts making them punishable by severe penalties. It is mainly concerned with acts other than those pertaining to the unlawful seizure of aircraft. The protocol supplementary to the Montreal Convention of 1971 was adopted in 1988 by the ICAO Conference and extends the definition of offences given in the 1971 Convention to include specific acts of violence at airports serving the civil aviation community. To provide international weight to these conventions, all contracting states have agreed to make the identified offences punishable by severe penalties. You will recall that Annex 17 of the ICAO Convention deals with security and requires signatory states to adopt the SARPs and establish security authorities, programs and mechanisms for determining threat levels. Of course, to make all of these conventions work, training programs are essential, and all signatory states are required to implement such programs and plans. Additionally, as an ongoing commitment to security, each state is required to cooperate with other states in the research and development of security systems and procedures which will better satisfy security objectives. The ICAO conventions allow any aircraft commander who has reasonable grounds the ability to restrain any party on board, and to protect the safety of the aircraft, persons or property on board, maintain good order on board, deliver or disembark any person to the competent authorities if he believes they are jeopardizing the aircraft. While the commander can demand help from a member of the crew, he or she can only request the aid of a passenger or other non-crew member. You should now understand that the protection of all aspects of international air transportation is a complex one and a constantly changing situation. The cooperation between signatory states to ensure that the highest standards of aviation security apply, whilst maintaining the advantages of the expeditious nature of air travel, is essential. Although most regulation has been defined and adopted by all states throughout ICAO, some states within their own regions have created separate additional layers of regulation, an example of which is the European Union, the EU. This lesson will therefore briefly mention the regulations and the governing bodies within Europe. The driving force for a common civil aviation policy across Europe is the European Civil Aviation Conference, ECAC. Set up in 1955 under the auspices of the EU and ICAO, its aim is to define a European approach to a general structure for civil aviation in Europe, licensing, safety, European regional air traffic control, and a structure for civil aviation marketing within Europe. Because of its established position within Europe, ECAC is able to be the forum for the consideration of major civil aviation topics relevant to all the European states. The Joint Aviation Authorities, JAA, is an associated body of the ECAC, representing the civil aviation regulatory authorities of a number of European states, who have agreed to cooperate in developing and implementing common safety regulatory standards and procedures. The JAA membership is based on signing the JAA Arrangements document, originally signed by the then current member states in Cyprus in 1990. The JAA's work began in 1970, and its original objectives were only to produce common certification codes for large aeroplanes and engines. From 1987, its work has been extended to operations, maintenance, personnel licensing, and certification and design standards for all classes of aircraft. With the adoption of new regulations in 2002 by the European Parliament and the Council of the European Union, a new regulatory framework was created under the European Aviation Safety Agency, EASA. This new agency of the European Union has subsumed the responsibilities of the Joint Aviation Authorities. EASA is the sole European regulatory and executive body concerning civil aviation. Presently, the JAA now only exists in a transitional phase to help liaise between EASA and the civil aviation authorities of the non-EASA JAA member states. Eurocontrol was founded in 1960, with the objective of providing common air traffic services in the airspace of European states, the Single European Sky Initiative, and strengthening cooperation between members in the matter of air navigation. Today, it has a much wider remit, most notably in the field of air traffic flow management, which has led to the establishment of the Eurocontrol Central Flow Management Unit. In 1990, a harmonised licence for air traffic controllers in Europe was launched, when the ECAC transport ministers called for the development of guidelines for the training and licensing of air traffic staff in ECAC states. This work became part of the European Air Traffic Control Harmonisation and Integration Programme, As Europe as a whole continues to evolve and adapt, the European aviation community will also constantly change and evolve. So to stay fully abreast of the changes, make sure that you consult with your instructor regularly to stay fully up to date. A more recent ongoing development is the European Air Traffic Management Programme, which, through its ATM 2000+ initiative, will allow gate-to-gate clearances. That is, an air traffic control clearance all the way from the departure to the destination airport. In this lesson, we will very briefly examine the history and details of the Warsaw Convention and its associated documents with regard to carrier liabilities. In 1929, it was established that civil air transport carrier liabilities and responsibilities needed to be addressed, as international air transportation was beginning to boom. The Warsaw Convention started this process. Over the years, the articles of the Convention were improved on by the Hague, Warsaw and Montreal protocols, which now mean that firm rules on carrier responsibility and liability have been established. The Warsaw Convention mandates carriers to issue passenger tickets, requires carriers to issue baggage checks for checked luggage, establishes the principle of absolute liability of the air carrier, and limits a carrier's liability to at most 100,000 special drawing rights, SDR, for death or personal injury, 17 special drawing rights per kilogram for cargo, and 1,000 special drawing rights for personal baggage. The liability values were originally given in poincaré francs, but this was amended at the Montreal Protocol to substitute the liability into special drawing rights. The value of a special drawing right is similar to a currency, and, much like a currency, its value varies over time. The approximate value of one special drawing right is £1 sterling. For an up-to-date value of the special drawing rights, please see the website of the International Monetary Fund, the IMF. As a result of the numerous emerging national airlines and operators during the previous century, there grew a wide variety of ticketing types and passenger and freight contracts. These proved very inefficient and were going against the harmonisation that ICAO had tried to set up. To resolve this, the International Air Transport Association, IATA, drew up an agreement between ICAO member states to have a common ticketing, post and freight carriage system that holds common international liabilities. The Multilateral Interline Traffic Agreement, MITA, forms the basis of the Multilateral Interline System, MIS. Some 300 operators now accept each other's tickets and airway bills, and thereby their passengers and cargo traffic, on a reciprocal basis. A standard format for tickets and waybills exists, and resolutions govern how they are produced. This also means that a passenger can fly complex routes all around the world in one transaction and in one currency. This multilateral system helps save the world airline travel market $3 billion and demonstrates the effectiveness of cooperative practices. As long ago as 1919, international meetings agreed that the rules of the sea would also apply to the air. So an aeroplane is regarded as carrying the same status as that of a ship. In practice, this means that the laws of any nation apply to an aeroplane whilst it is airborne over that nation or an international airspace. Over the airspace of another land, the laws of that land apply. The captain of the aeroplane is invested with the authority to uphold these laws. The laws of the state of registry therefore apply to aeroplanes in the same manner that they apply to ships at seas. It is further required that the operator nominate a captain from one of the fully qualified crew members to enforce the articles of Annex 6 to the Chicago Convention. Essentially, he is responsible for the operation and safety of the aircraft, and for the safety of all persons on board during flight time. flight time being the period from brakes off to brakes on, or for helicopters, the period when the rotors are turning. Remember that the protocols to the Warsaw Convention are in place to counter the unlawful interference of an aeroplane and to counter the perpetration of unlawful acts on board. It is the duty of the aircraft captain to enforce this. The Operations Manual defines in Part 1 the duty and responsibilities which, by virtue of the validation of the Operations Manual by the authority, are confirmed as being that as required by national law. The Rome Convention of 1952 deals with the damage by foreign aircraft to third parties on the ground. The Convention endorses the concept of absolute liability of the aircraft operator for damage caused to third parties on the surface, but places a limitation on the amount of compensation. It also provides for compulsory recognition and execution of foreign judgments. During the 20th century, the global economy developed enormously, and many international trade alliances, free trade zones, and economic tariff barriers were set up. Whilst this was fine for the countries concerned, this led to some severe trade protectionism, which in turn severely restricted the growth of commercial air traffic enterprises. Added to this, the escalating costs of aircraft and fuel, and the monopolization of the major air routes by the large national carriers, led to a general inability of the smaller air carriers to flourish. To survive, smaller organisations turned to the leasing of aircraft to minimise their costs. This meant that the whole issue of liabilities, insurance and safety urgently needed addressing, and this was recognised by the ICAO as early as 1948, through the Convention on the International Recognition of Rights in Aircraft. Leasing became defined as the situation whereby an aeroplane is used by one operator, whilst the ownership title remains with another operator. The following terminology is generally used with regard to the leasing of aircraft. Wet lease is when the leased aeroplane is operated under the Air Operator Certificate, AOC, of the lessor, the operator lending the aeroplane to the lessee. Dry lease is when the leased aeroplane is operated under the Air Operator Certificate of the lessee, the operator borrowing the aircraft. Leasing between JAA operators has become commonplace, together with the terms wet or dry lease out or in. Permission must be obtained from the regulatory authorities to undertake such leases. Leasing of aeroplanes at short notice is permitted to ensure that air transport obligations are met. It is a given that permission is approved, subject to the following conditions. The lessor holds an AOC issued by an ICAO state. The lease-in period does not exceed 5 consecutive days, and the authority is notified of the arrangement as soon as possible. The European Union, however, took the view that it needed to legislate for aircraft leasing arrangements independently of the international systems. EU signatories are bound by EC Council Regulation 2407/92, which contains all the provisions on leasing. Its declared aim is to harmonise policy to the highest possible degree. The World Trade Organization and the General Agreement on Trade in Services for Aviation, WTO GATS, also establishes procedures that lead to the abolition of unfair practices and encourages growth in the global aviation economy. In 1948, the Council of the ICAO established rights in aircraft on air traffic. This relates to the international laws that concern ownership of aircraft and the rights of the lender or mortgagee, and recognises ownership and rights of possession. You will now recall that the airworthiness standards of the Chicago Convention, Annex 8, are related to Annex 6, that deals with aeroplane performance. This realises that the operation of aeroplanes is intrinsically related to the safety of them, that is, the airworthiness of them. The airworthiness of aeroplanes is therefore not just fully defined by the application of the standards of Annex 8, but also the standards of Annex 6, which are complementary. Annex 8 deals with the engineering aspects, whereas Annex 6 deals with the safety of the operation of the aircraft. The standards apply to performance and operation. Over the past decade, the applicability of Annex 8 has widened to include many aircraft types. However, as far as we are concerned, in this course, we will consider that the standards of airworthiness are applicable to all aircraft over 5,700 kilograms maximum certified takeoff mass, intended for the carriage of passengers, cargo or mail in international navigation. And, unless specifically exempted, the standards apply to the complete aeroplane, including their power units, systems and equipment. For the standards to be applicable, the aeroplane must have at least 2 engines. A certificate of airworthiness is to be issued by the State of Registry when satisfactory evidence is provided that the aeroplane complies with the appropriate airworthiness requirements. ICAO has specified a standard form for the Certificate of Airworthiness, C of A, which includes the nationality and registration marks of the airframe, the manufacturer and designation of the aircraft, along with the aircraft serial number. The State of Registry of an aeroplane is responsible for determining if that aircraft continues to be airworthy, and is required to maintain a system for recording faults, malfunctions, defects or other occurrences which might affect its airworthiness. The state of design is required to ensure that a structural integrity program exists, supporting all aircraft. This program must specifically identify corrosion control measures. The C of A will be renewed or remain valid, provided that the continued airworthiness of the aeroplane has been determined by a periodic inspection. The period between inspections is to take into account the type of service and the time elapsed between inspections, or be in accordance with the system of inspection established by the state. When an aeroplane is damaged, then the State of Registry must establish whether the damage is of such a nature that the aircraft is no longer airworthy. Each aircraft is required to have a flight manual, in which the approved limitations are defined, and any additional information is contained as is necessary for the safe operation of the aeroplane. As aviation grew rapidly during the early part of the century, the need to communicate with the ever-increasing number of aeroplanes in the sky made it necessary to ensure that all aeroplanes could be uniquely identified, much like cars are identifiable by their registration number. Therefore, as early as 1919, at the Paris Convention, delegates decided that all aircraft were to be registered, and that each aircraft was to display its registration mark. Annex 7 to the Chicago Convention covers this requirement in more detail, and specifies the standards for registration and registration marks. Authorities may exempt an aircraft from registration in certain circumstances. Aircraft under test, or historic aircraft, for example. The table here illustrates the different classifications of aircraft, and is used to determine where nationality marks and registration marks are displayed on aircraft. Although it is not necessary to remember this table, it would be useful to gain an appreciation of the first few major classifications shown to the left-hand side of the table. When you have finished looking through this information, click the forward flashing arrow in the bottom right-hand side to continue. It was decided that the nationality and registration marks would consist of a group of characters, with the nationality mark followed by a hyphen if the first character of the registration mark is a letter, then followed by a 3 to 5 character registration mark. The nationality mark is selected from the series of nationality symbols included in the radio call signs, allocated to the state of registry by the International Telecommunications Union. This code is notified to ICAO and may consist of letters, numbers, or both. A common mark is a prefix to an aircraft's registration, where the aircraft is operated by an international agency, not a country, like the Red Cross or United Nations. If this is the case, an establishing nation will assume the responsibility as the state of registry. This mark is assigned by the ICAO. A good example is the common mark 4YB, assigned to aircraft of the Arab Air Cargo, run by Jordan and Iraq. The state of Jordan assumes state of registry. Certain combinations of letters, numbers, or marks may coincidentally correspond to other well-known aviation emergency coding. So to avoid any possible confusion, the following combinations of letters and symbols are not permitted. Combinations starting with the letter Q and 5-letter combinations used in the International Code of Signals are also not permitted. The Certificate of Registration is an official document certifying that the state of registry has registered the aircraft. It will always detail the nationality or common mark, the registration mark, the manufacturer's designation of the aircraft, the serial number of the aircraft, the name and address of the owner, a certificate stating that the aircraft has been entered on the register of the state, the dated signature of the registering officer. The certificate is to be carried in the aircraft at all times. A nationality supplement to Annex 7 contains information regarding aircraft nationality marks notified to ICAO at Part B. These are listed alphabetically by state and by marks. Part A of the document registers the differences that have been notified to ICAO by contracting states. Each state is required to notify ICAO if differences exist, no differences exist, no information has been received. Notified differences are listed by state in the final part of the annex. States are also required to list these differences in their own air information publication documents. The nationality or registration marks are to be painted onto the aircraft or affixed by any means that ensures a similar degree of permanence. The marks shall be kept clean and visible at all times. The required markings are to appear on the lower surfaces of the wing, the fuselage between the wings and the tail, or on the upper half of the tail surface. As you can see, this aircraft has positioned its vertical tail marks incorrectly. The markings on the wings are to be at least 50 centimetres high, and on the fuselage and vertical surfaces, 30 centimetres high. This completes the lesson on aircraft registration markings. You should now understand why aircraft need to be registered, how aircraft are registered, and what the registration mark means, which registration marks are not suitable, and where the registration mark is to be displayed on aircraft. The rules established by ICAO for the licensing of aircrews are contained in Annex 1 to the Chicago Convention. These are rules which have received the general agreement of all ICAO contracting states, although individual nations and groups of nations may have registered differences as far as the detail of the rules is concerned. The Joint Aviation Authority's Air Transport Pilot's Licence syllabus is therefore based firmly on ICAO standards and recommended practices and procedures for air navigation services. However, JAA rules and regulations may at times differ from ICAO practices and procedures. Consequently, in order to meet the learning objectives of the JAA ATPL Air Law course, you also require knowledge of personnel licensing as published in ICAO Annex 1. As you have already learnt, the JAA's responsibilities are being taken over by the European Aviation Safety Agency, EASA. This development may have a consequence for the naming of the current JAA licences and the detail of the regulations. Joint Aviation Requirements, Flight Crew Licensing, or JAR-FCL, is the name given to the JAA organisation and documentation governing the JAA regulations for the flight crew licensing of aeroplane and helicopter pilots, and also of flight engineers. ICAO Annex 1 is a source document for the JAR-FCL series of documents. The Joint Aviation Requirements, Flight Crew Licensing document is divided into 4 parts. Part 1, the requirements for aeroplane pilots. Part 2, the requirements for helicopter pilots. Part 3, the medical requirements for pilots. Part 4, the requirements for flight engineers. It is a requirement of joint aviation regulations that no person is to act as a flight crew member of a civil aeroplane registered to a JAA member state unless that person holds a valid licence and rating complying with the requirement of Joint Aviation Regulations, flight crew licensing, appropriate to the duties being performed. A student pilot is permitted to fly solo only if he has been authorised to do so by an authorised flying instructor. A JAA flight crew licence may be issued by a JAA member state, or by another ICAO contracting state, provided that, in this latter case, the licence is rendered valid in accordance with Joint Aviation Regulations, as contained in JAR-FCL 1 for a pilot of aeroplanes, or JAR-FCL 2 for a helicopter pilot. If it is established that an applicant for or holder of a JAA licence has not met or no longer meets JAR-FCL 1 requirements, or no longer complies with the relevant national regulations of the state of licence issue, then a JAA member state has the right to suspend or revoke any licence or rating, or to limit the privileges of that licence or rating. A Joint Aviation Authority's licence is valid for a period of 5 years. Consequently, on or before the expiry date printed in the licence itself must be renewed in accordance with Joint Aviation Regulations. However, as well as having its own validity period, the validity of a JAA licence is also determined by the validity of the ratings contained in the licence and by the validity of the medical certificate. For example, a pilot who holds an airline transport pilot's licence, which itself has not expired, will not be able to exercise the privileges of his licence on aircraft for which he is type rated if the type rating has expired. As a type rating is valid for 1 year only, you can see that a type rating needs to be revalidated several times during the period of validity of the licence itself. Similarly, an instrument rating is valid for 1 year only, and a medical certificate may, on an ATPL, be valid for 1 year or 6 months, depending on the age of the pilot. In conclusion then, all ratings and the medical certificate must be maintained valid in order that the licence itself remain valid. Within the 5-year period of validity of a JAA licence, a national authority, referred to as the authority in JAA speech, will reissue the licence in the following circumstances. After initial issue of a rating or renewal of a rating, at the discretion of the authority when a rating is revalidated. The holder of a pilot licence who has attained the age of 60 is not permitted to act as pilot in command of an aeroplane engaged in commercial air transport work, except as a member of a multi-pilot crew, and provided that the other pilot has not attained the age of 60. A pilot reaching the age of 65 is not permitted to act as a pilot of an aeroplane engaged in commercial air transport. This limiting age is 60 in some member states. For example, France. Applicants for a Joint Aviation Authorities licence must complete the requirements for licence issue to the satisfaction of the National Aviation Authority of the state under whose authority the training and testing for the licence were carried out. That state, on issuing the licence, then becomes the state of licence issue. The state of licence issue is the country in which the aviation authority which authorises a person to act as a pilot is headquartered. Despite the multinational nature of the JAA, each nation's aviation authority acts under the authority of the legislature of that nation. Hence, the Civil Aviation Authority is the licence issuing authority for the United Kingdom. It is permitted for a student pilot to commence his training in one state and complete it in another state. In this case, the national aviation authorities of the states concerned will agree which state is to act as the state of licence issue. If the holder of a licence requires additional ratings or authorisations, in accordance with JAR FCL, these may be obtained in any JAA state and subsequently be entered in the licence by the state of licence issue. It is permitted for a licence holder to make a request for his licence to be transferred from one JAA state to another if there is an administrative need to do so. This action might be taken, for instance, if a JAA licence holder changes his state of normal residency, or if he takes up employment in a new state. In these cases, the new state may become the state of licence issue. The state of normal residency is the state in which a pilot normally resides for at least 185 days in any year. In this lesson, we shall look at the requirements for the issue of a commercial pilot's licence and the privileges able to be exercised by the holder of a commercial pilot's licence. While much of what you will learn in this lesson applies to both aeroplane and helicopter pilots, when we enter into specific details of the commercial pilot's licence, we shall be referring to the commercial pilot's licence aeroplanes. An applicant for a commercial pilot's licence, which we shall henceforth refer to as the CPL, must have attained the age of 18 years and hold a valid Class 1 medical certificate. A person wishing to obtain a CPL may enter full-time training, often referred to as integrated training, as an ab initio student. That's a student with no previous flying experience, or with a private pilot's licence qualification. Integrated training must be carried out at an approved flying training organisation. The integrated CPL course consists of theoretical knowledge instruction and visual and instrument flying training. An applicant for the CPL must be able to demonstrate a level of knowledge appropriate to the privileges of his licence in the subjects shown on screen here. A pass in the CPL theoretical knowledge examinations in the above subject is accepted as proof of the required level of knowledge. The theoretical knowledge training course for the CPL must comprise at least 300 hours of instruction covering all the subjects mentioned, or 200 hours of instruction if the student is the holder of a PPL. Flying training for the CPL, but not including type rating training, must comprise at least 150 hours flight time, of which up to 5 hours for the entire course may be instrument ground time. The 150 hours may include progress tests. Within the 150 hours total flying time, CPL student pilots must complete at least 80 hours of dual instruction, of which up to 5 hours may be instrument ground time, 70 hours as pilot in command, 20 hours of cross-country flight as pilot in command, including a VFR cross-country flight totaling at least 300 nautical miles, that's 540 kilometres, during the course of which full-stop landings are made at 2 aerodromes different from the aerodrome of departure, 5 hours night flying, comprising 3 hours of dual instruction, to include at least 1 hour of cross-country navigation, as well as 5 solo takeoffs and 5 full-stop landings, 10 hours of instrument flight instruction, of which up to 5 hours may be instrument ground time in an FNPT 1 or 2 or flight simulator. 5 hours of flying instruction must be carried out in an aeroplane certificated for the carriage of at least 4 persons, and have a variable pitch propeller and retractable landing gear. In the case of an entrant to CPL training who already possesses a PPL, 50% of the aircraft hours flown by the entrant prior to commencing the CPL course may be credited towards the required flying instruction, up to 40 hours flying experience, or 45 hours if a night flying qualification has been obtained. The aim of the CPL modular course is to train PPL holders who do not wish or who are unable for any reason to undergo integrated training to the level of proficiency necessary for the issue of a CPL. Consequently, before commencing a CPL modular course, an applicant must hold a private pilot's license, issued in accordance with ICAO Annex 1. Before beginning flying training for the CPL as part of a modular course, a student pilot must have completed 150 hours flight time as a pilot. CPL students without an instrument rating must undergo at least 25 hours dual flying instruction, including 10 hours of instrument instruction, of which up to 5 hours may be instrument ground time, using an approved flight simulator. Additionally, CPL students without a night flying qualification must undergo at least 5 hours night flying instruction. At least 5 hours of flying instruction must be carried out in an aeroplane certificated for the carriage of at least 4 persons, and have a variable pitch, constant speed propeller, and retractable landing gear. The CPL via the modular route will not be issued unless the applicant has obtained at least 200 hours flying experience, of which 100 hours are as the pilot in command. The other requirements are identical to those needed when following the integrated path. Theoretical knowledge instruction for the CPL modular course may be given at a flying training organisation approved for the delivery of theoretical knowledge instruction only. Whatever the type of FTO at which the CPL modular course is taken, theoretical knowledge training on a modular course must comprise at least 200 hours of instruction in the ground subjects shown on screen here. Following the date of gaining a pass in all theoretical knowledge examinations, a CPL student has 36 months to complete flying training and to fulfil any further requirement for the award of a CPL. Subject to any other conditions specified in Joint Aviation Regulations, the holder of a CPL aeroplanes may exercise the following privileges. Exercise all the privileges of the holder of ATPL aeroplanes, act as pilot in command of any aeroplane engaged in operations other than commercial air transport, act as pilot in command of any single pilot aeroplane certificated for commercial air transport, act as co-pilot of an aircraft engaged in commercial air transport that requires a co-pilot, but only having passed the theoretical knowledge for ATPL-A prior to the type rating on that aeroplane. That completes the lesson on the commercial pilot's license. Before a pilot may be granted, or continue to exercise, the privileges of a Joint Aviation Authority's airline transport pilot's license, he must hold a valid Class 1 medical certificate and have attained the age of 21 years. Subpart G to JAR FCL1 covers the conditions which must be fulfilled before a JAA Air Transport Pilot's Licence, aeroplanes, may be issued. An applicant for a JAA ATPL must undergo the prescribed syllabus of training at an approved flying training organisation. Training for the JAA ATPL consists of flying instruction and theoretical knowledge instruction. Flying instruction must lead to the award of a commercial pilot's licence, together with a multi-engine instrument rating. The ATPL candidate must also have received instruction in multi-crew cooperation, as required by Joint Aviation regulations. On completion of flying training, an ATPL candidate must demonstrate the ability to perform, as pilot in command under instrument flight rules, of an aeroplane type certificated for a minimum crew of 2 pilots, to a standard appropriate to the privileges granted to the holder of an ATPL. The training requirements for issue of a JAA ATPL are not confined to flying training. In order to qualify as an airline transport pilot, a student must also demonstrate that he has acquired the theoretical knowledge required of a qualified airline transport pilot by passing ground examinations at ATPL level in the subjects shown on screen here. In addition to the required training, before being awarded an airline transport pilot's licence, aeroplanes, a pilot must have completed at least 1,500 hours of flight time as a pilot of aeroplanes, of which not more than 100 hours may have been completed in an approved flight simulator. The 1,500 hours total flying time required for the award of a JAA ATPL aeroplanes must include the following experience. Click on the inset picture to reveal each required type of flying experience. When all conditions have been revealed, the Continue button will flash. "500 hours of multi-engine operations in a transport category or commuter category aeroplane or aeroplane of equivalent code, 250 hours as pilot in command, or at least 100 hours as pilot in command and 150 hours as co-pilot acting as PIC, but under the supervision of the pilot in command. 200 hours of cross-country flying, of which 100 hours shall be as pilot in command or as co-pilot performing under the supervision of a pilot in command. 75 hours of instrument time, of which not more than 30 hours can be instrument simulator ground time. 100 hours of night flying as pilot in command or co-pilot, again as the handling pilot, acting as PIC, but under the supervision of the pilot in command. The holder of a Joint Aviation Authority's airline transport pilot's licence, aeroplanes, is permitted to act as pilot in command or co-pilot of an aeroplane engaged in air transport operations, and to exercise all the privileges of the holder of a private pilot's license, aeroplanes, a commercial pilot's license, aeroplanes, or an instrument rating, aeroplanes. In this lesson, we will look at the ratings which must or may be added to a pilot's license. Some ratings, therefore, are required to be included in a license, while other ratings are optional. For instance, a pilot must hold a valid class or type rating for the aeroplane he flies, and he may not conduct any form of flying instruction unless he holds a flight instructor's rating. Let's begin at the beginning. Even though a pilot is the holder of a valid pilot's license, he is not permitted to act in any capacity as a pilot of an aeroplane unless he has a valid and appropriate class or type rating for that aeroplane. The only exception to this regulation is when a pilot is receiving flight instruction with an authorized instructor or undergoing a skills test with an authorized examiner. Consequently, in addition to a pilot's license, a pilot is also required to hold a valid class or type rating for any aeroplane that he wishes to fly. Generally, class ratings apply to simple aircraft, whereas a type rating is required for a more sophisticated aircraft. For example, a private pilot wishing to fly single-pilot, single-engine piston land aircraft only will need just the one class rating to fly any aircraft of that class. One of the class ratings, for instance, is single-engine piston land. This includes the PA-28 Warrior, de Havilland Chipmunk, or any other similar aeroplane. If a private pilot then wished to progress to flying single-pilot, twin-piston engine aircraft, he need only acquire a further class rating for that class of aircraft, so that he could then fly any aircraft of that class. On the other hand, the holder of a commercial or air transport pilot's license, who flies as a pilot on any multi-pilot aircraft, requires a separate type rating for each type of aircraft he flies. Class ratings do not apply here. For instance, a separate type rating is required for aircraft such as the Boeing 737, the Dash 8, or the Airbus A320. If a pilot wishes to fly different classes or types of aeroplane, he will be required to receive appropriate training and pass a separate skill test on each class or type of aeroplane he intends to fly. In general, it may be stated that, with the exception of pilots undergoing a skill test or dual training, holders of a Joint Aviation Authority's pilot license, aeroplanes, may not act in any capacity as a pilot of an aeroplane flying under the instrument flight rules unless their license includes a valid instrument rating, issued in accordance with Joint Aviation regulations, and which is appropriate to the category of aircraft they are flying. Some JAA member states, however, such as the United Kingdom, permit non-instrument rated pilots to fly under the instrument flight rules under certain specified conditions, for instance, along advisory routes. The United Kingdom also has a national IMC rating, which permits the holder to fly in IFR and also in instrument meteorological conditions, again, in certain specified circumstances. National IMC ratings are restricted to use in the airspace of the state of license issue only. We'll now take a closer look at the different kinds of ratings. Let's look at class ratings first. As we have said, a class rating is usually issued with a private pilot's license. A class rating qualifies a pilot to fly as pilot in command of any aeroplane within that class. class ratings are issued for the following classes of aeroplanes. All single-engine piston aeroplanes, land. All single-engine piston aeroplanes, sea. All touring motor gliders. Each manufacturer of single-engine turboprop aeroplanes, land. Each manufacturer of single-engine turboprop aeroplanes, sea. All multi-engine piston aeroplanes, land. All multi-engine piston aeroplanes, sea. There is no limitation on the number of class ratings that a pilot may hold at any one time. JAROPS regulations, however, may restrict the number of ratings that can be exercised at any one time. To obtain a class rating, a pilot will need to attend a class rating course for the relevant type, consisting of both theoretical knowledge and flying instruction, pass a theoretical knowledge examination, pass a skill test on an appropriate aircraft type, conducted by a class rating examiner. Although a class rating, in general, qualifies a pilot to fly any aeroplane within that class, differences training may be required in order that he may pilot a variant of aircraft within the class, but which has markedly different flying characteristics and technical and performance specifications. For the single-engine piston land class rating, the class rating held by the majority of PPL holders, differences training with an improved instructor is required when changing from the simple, light, fixed, tricycle undercarriage, fixed-pitch propeller aeroplane, shown on screen here, to aeroplanes displaying the following features: variable pitch constant speed propeller, retractable undercarriage, turbocharged or supercharged engine, cabin pressurization, tailwheel. Successful completion of differences training does not result in the issue of any sort of certificate. The fact that differences training has been successfully completed is entered in the pilot's logbook or equivalent document and signed by a flight instructor, class rating instructor, or type rating instructor, as appropriate. Now let's look at type ratings. As we have said, type ratings apply to more sophisticated types of aircraft. For instance, the holder of a commercial or air transport pilot's license normally requires a separate type rating for each type of aircraft he flies. For example, a Boeing 737, Airbus A320, or Dash 8. There is no JAR FCL limit to the number of ratings that may be held at one time. JAROPS, however, may restrict the number of ratings that can be exercised at any one time. In general, type ratings are required for each type of multi-pilot aeroplane, each type of single-pilot multi-engine aeroplane fitted with turboprop or turbojet engines, each type of single-pilot single-engine aeroplane fitted with turbojet engines, any other type of aeroplane considered necessary by the National Aviation Authority. To obtain a type rating, a pilot will need to attend a type rating course for the relevant aircraft type, consisting of both theoretical knowledge and flying instruction, pass a theoretical knowledge examination, pass a skill test on the aircraft type, conducted by a type rating examiner. As you have already learnt, the validity of a pilot's license is dependent on the validity of the ratings it contains and the currency of the associated medical certificate. In the next few sections, we will look at the period of validity of the ratings and any conditions which need to be fulfilled for their revalidation. For instance, single-pilot, single-engine piston class ratings, including touring motor glider ratings, are valid for 2 years. In order to revalidate this type of rating, the pilot must either pass a proficiency check with an authorised examiner within the 3 months preceding the expiry date of the rating, or, within 12 months of the expiry date of the rating, have flown 12 hours on an aircraft of the relevant class, to include 6 hours as pilot in command, 12 takeoffs and 12 landings, a training flight of at least 1 hour's duration with a flight instructor or a class rating instructor. Type ratings and multi-engine piston class ratings for aeroplanes are valid for 1 year from the date of issue. If the rating is revalidated within its period of validity, the new rating will be valid from the date of expiry of the old rating. In order to revalidate a type rating or multi-engine class ratings, aeroplanes, a pilot must fulfill the following conditions: undergo a proficiency check with an authorised examiner, for instance a type rating examiner, in the relevant type or class of aeroplane within the 3 months immediately preceding the expiry date of the rating. During the period of validity of the rating, the pilot must also carry out at least 10 route sectors as pilot of the relevant type or class of aeroplane, or 1 route sector as pilot of the relevant type or class of aeroplane, flown with an examiner. In order to change to another variant of the aeroplane within one type rating category, for instance there is one type rating for both the Boeing 757 and the Boeing 767, differences or familiarization training may be required. If a pilot fails any part of a proficiency check for a class rating or type rating, he must not exercise the privileges of that rating until all the parts of the proficiency check have been successfully completed. If a type rating or multi-engine class rating has expired, the rating must be renewed. In order to renew a rating, a pilot must satisfy any refresher training requirements as determined by the appropriate National Aviation Authority, as well as completing a proficiency check. The rating will then be valid from the date of completion of the renewal requirements. With the exception of pilots undergoing a skill test or dual training, and certain national conditions for private pilot holders, holders of a Joint Aviation Authority's pilot licence may not act in any capacity as a pilot of an aeroplane or helicopter flying under the instrument flight rules, unless their licence includes a valid instrument rating issued in accordance with Joint Aviation regulations, and which is appropriate to the category of aircraft they are flying. An instrument rating is valid for 1 year from the date of issue or renewal, or from the expiry date of a current instrument rating if revalidated before the expiry date is reached. If the instrument rating is restricted for use in multi-pilot operations only, the revalidation or renewal will be carried out during multi-pilot operations. If the instrument rating has not been revalidated or renewed within the preceding 7 years, the holder will be required to retake the instrument rating theoretical knowledge examination, as well as the skills test. An applicant for an instrument rating must hold a PPL, including a night qualification, or CPL, and must have completed at least 50 hours cross-country flight time as pilot in command in aeroplanes or helicopters. An applicant for an instrument rating must have received theoretical knowledge instruction on an improved course at an improved flying training organisation. The course should, wherever possible, be combined with a flying training course. The revalidation of an instrument rating should be combined with the type or class rating proficiency check. There are 7 instructor ratings for aeroplanes recognised under Joint Aviation Regulations. Click on the head of the instructor in the right-hand seat to reveal the 7 instructor categories. The flight instructor rating itself. A fully qualified flight instructor is the person who teaches you basic and advanced flying skills. A flight instructor who has no restrictions on his rating can teach a student all types of flying skills, including night flying and instrument flying. The type rating instructor. A type rating instructor, as the name suggests, can prepare a pilot, usually a professional pilot, who is qualified on one type of aircraft to become qualified on a different type of aircraft. The class rating instructor. A class rating instructor can prepare a pilot, usually a private pilot, who is qualified on one class of aircraft to become qualified on another class of aircraft. The instrument rating instructor. The synthetic flight instructor authorization. The multi-crew cooperation instructor authorization. The synthetic training instructor authorization. In addition, the multi-crew pilot's license, MPL authorization, will allow any of the instructor ratings above to instruct a student following the MPL program. For the remainder of this lesson, we will look a little more closely at flight instructor ratings. Before being permitted to begin an approved course of training to become a flight instructor, an applicant must have satisfied the following conditions: be at least 18 years old, either possess a commercial pilot's license or higher level of license, or, if holding only a private pilot's license, have at least 200 hours flight time, of which 150 hours must be as pilot in command, have met the theoretical knowledge requirements for a commercial pilot's license or higher level of license, have received at least 10 hours instrument flight instruction, of which not more than 5 hours may be instrument ground time in a flight navigation procedures trainer or flight simulator, have passed a specific pre-entry flight test within the 6 months preceding the start of the flight instructor's course, have completed at least 30 hours on single-engine piston aircraft, of which at least 5 hours must have been completed during the 6 months preceding the pre-entry flight test, have completed at least 20 hours of cross-country flight as pilot in command, including a flight totalling not less than 540 kilometres, or 300 nautical miles, in the course of which full-stop landings at 2 different aerodromes must be made. In this section, we cover the privileges of the flight instructor rating. Until the holder of a flight instructor rating has completed at least 100 hours of flight instruction and, in addition, has supervised at least 25 student solo flights, the privileges of the rating are restricted. These restrictions will be removed from the rating when the above requirements have been met, and on the recommendation of the supervising flight instructor. There are several privileges which appertain to the holder of a flight instructor rating, provided certain conditions have been fulfilled. However, in effect, certain restrictions continue to apply to the flight instructor rating until the conditions are fulfilled. Here are some examples of flight instructor privileges, and the conditions which must be fulfilled before those privileges can be exercised, once the initial restriction, that we have just mentioned, is lifted. A flight instructor who holds an unrestricted flight instructor rating may conduct flight instructions for the issue of the private pilot's license and for class ratings for single-engine piston-driven aeroplanes. The holder of an unrestricted flight instructor rating may carry out flight instruction for the issue of a commercial pilot's license, provided that he has completed at least 500 hours of flight time as a pilot of aeroplanes, including at least 200 hours of flight instruction. The holder of an unrestricted flight instructor rating may carry out flight instruction in night flying, provided the instructor holds a night qualification and has demonstrated his ability to instruct at night to an appropriately qualified night flying instructor, and provided that the JAR FCL night currency requirement is satisfied. The holder of an unrestricted flight instructor rating may carry out flight instruction for the issue of an instrument rating, provided that he has at least 200 hours flight time in accordance with instrument flight rules, and completed as a student an approved course comprising at least 5 hours of flight instruction in accordance with joint aviation requirements. Further privileges appertain to the holder of an unrestricted flight instructor rating, such as conducting flying training for the issue of a multi-engine instrument rating, single-pilot multi-engine class rating, and to train student flight instructors, provided that the required conditions of experience and training have been fulfilled. That completes the lesson on ratings. The holder of a pilot's license must be mentally and physically fit to exercise safely the privileges of his license. Consequently, as well as the validity of a pilot's license being determined by the validity of the class or type ratings which must be included in that license, the license must also be accompanied by a valid medical certificate, issued in accordance with the provisions of JAR FCL 3. An applicant for the issue, revalidation or renewal of a Joint Aviation Authority's private pilot's licence must hold a valid Class 1 or Class 2 medical certificate. An applicant for the issue, revalidation or renewal of a Joint Aviation Authority's commercial pilot's licence or air transport pilot's licence must hold a valid Class 1 medical certificate. The medical examination for the issue of both a Class 2 and a Class 1 medical certificate must be conducted by an authorised medical examiner. JAA Class 1 medical certificates are valid for 12 months for pilots up to age 60, and over age 60 for 6 months. JAA Class 2 medical certificates are valid for 60 months up to age 40, for 24 months between the ages of 40 and 50, and over the age of 50 for 12 months. If a pilot allows his medical certificate to expire, his licence becomes invalid immediately. If the medical examination for the revalidation of a medical certificate takes place within the 45 days prior to the expiry date of the current medical certificate, the validity of the new certificate extends from the previous certificate's expiry date. If a holder of a current JAA medical certificate becomes aware of any decrease in medical fitness, which will affect the safe execution of the privileges of his licence, he must cease to exercise those privileges until he has sought the advice of an authorised medical examiner and been declared fit to fly. More specifically, if the holder of a JAA medical certificate becomes aware of any of the circumstances or conditions shown on screen here, he must inform the National Aviation Authority of the condition in writing immediately. A hospital or clinic admission for more than 12 hours, any surgical operation or invasive procedure, the need for regular use of medication, the regular need to wear correcting lenses, an incapacitating injury, pregnancy. In the case of pregnancy, the suspension may be temporarily lifted during the early months of the pregnancy, and finally lifted after the end of the pregnancy when the pilot has been declared fit to resume flying. In the case of illness, any illness which incapacitates a pilot and prevents him from flying as a pilot throughout a period of 21 days or more must be reported in writing to the National Aviation Authority. A pilot's medical certificate, and therefore his pilot's licence, will be deemed to be suspended during any period of incapacity. The suspension will be lifted after a medical examination passes the pilot fit once more.
In this introduction to the section on rules of the air, we will look briefly at three issues. Firstly, at the origins of the establishment of rules of the air. Secondly, at the formulation by the International Civil Aviation Organization of rules of the air applicable to aircraft operating anywhere in the world. And finally, we will look at the basic concept of visual flight rules and instrument flight rules. Shortly after aircraft first flew at the beginning of the 20th century, rules of the air were established first of all by individual nations, and only later internationally. As time has progressed, the rules of the air have continuously evolved to cope with the ever-increasing sophistication of aircraft and the increasing density and range of aircraft movements. In the very early days of aviation, before the 1930s, few aircraft flew faster than 120 knots, and radio telephony communication between air and ground was a rarity. So many of the more basic rules of the air, which still apply nowadays, such as those dealing with landing priority and collision avoidance, were established to promote orderly and safe flight for non-radio air traffic, flying under visual flight rules in accordance with the principle of see and be seen. Therefore, many of the early rules of the air are still of great importance today for all aircraft, but especially for general aviation aircraft which still fly predominantly under visual flight rules. Between the First and Second World Wars, to improve safety at aerodromes, many nations throughout the world passed legislation to enforce the rules of the air which had become established in their states. But with the rapid expansion in international air traffic following World War II, it soon became apparent that it was of crucial importance to standardize the rules of the air between the nations. Not unnaturally, then, the topic of rules of the air was one of the first matters discussed at the Chicago Convention on International Civil Aviation held in 1944. The rules of the air agreed by the member states of what became the International Civil Aviation Organization are found at Annex 2 to the Convention on International Civil Aviation. It is instructive to consider at this point the words on screen taken from Article 12 of the Chicago Convention, as they put into context the agreement reached between the member states of ICAO. ICAO member states are referred to as contracting states. Every aircraft flying over a state's territory and every aircraft carrying a territory's national mark, wherever it is, must comply with that territory's rules of the air. Each state shall keep its own rules of the air as uniform as possible with those established under the Convention. The duty to ensure compliance with these rules rests with the contracting state. Over the high seas, the rules established under the Convention apply. Thus, all contracting states to the Chicago Convention agree to try to keep their national rules of the air in line with the ICAO rules. When a contracting state enforces a rule which differs from the ICAO rules of the air, that state files a difference with ICAO. Subsequently, in the airspace over which that state has jurisdiction, that state's rule takes precedence over the ICAO rule. The Joint Aviation Authorities and the European Aviation Safety Agency are organizations which have undertaken to seek to normalize the aviation regulations of their member states by bringing them into line with ICAO standards. It can be expected, then, that in the airspace of a nation-state which is an ICAO contracting state, that nation will have attempted to align its national rules of the air with ICAO rules of the air. But where there are differences, it is always the national rules which take precedence. However, ICAO rules of the air apply without exception over the high seas, that is, over those sea areas lying outside the territorial limits of any nation-state. The situation of which rules of the air apply to which aircraft can be quite complex, because many member states, such as the United Kingdom, also require that their own registered aircraft observe the UK national rules wherever they fly, as well as complying with the rules of the air of the state in whose airspace the aircraft are flying. Always remembering, of course, that the rules of the air of the state being overflown take precedence. The only straightforward situation is that, while flying over the high seas, ICAO rules of the air apply. Because of the complexity of the issue of which rules take precedence, it is fairly easy to see that if the national rules worldwide are standardized on ICAO rules, flying internationally will become a much more simple activity. However, though the current applicability situation is complex, it is not illogical, and should not be beyond the capacity of a pilot to understand. The situation can be summarized using the following example concerning an aircraft registered in the United Kingdom. For a United Kingdom registered aircraft flying over the United Kingdom rules of the air apply. For a UK registered aircraft flying over, say, France, French and UK rules apply, but the French rules take precedence. For UK registered aircraft flying over the high seas, ICAO rules apply without exception. One important general principle which flight crew must bear in mind is that it is the pilot in command of an aircraft, whether he is manipulating the controls or not, who is responsible for the operation of the aircraft in accordance with the rules of the air. However, the pilot in command may depart from these rules in circumstances that render such departure absolutely necessary in the interests of safety. The rules of the air that we have been referring to up to now are the general rules covered by Annex 2 of the ICAO Chicago Convention. And these general rules are aimed at ensuring that aircraft operations are safe and expeditious. However, in addition to the general rules of the air, aircraft commanders are subject either to the visual flight rules, referred to frequently as VFR, or the instrument flight rules, commonly known as IFR. When airborne, a pilot will always be flying in accordance with either the visual flight rules or the instrument flight rules. Note that a pilot does not necessarily have to be flying by sole reference to his instruments when flying in accordance with the instrument flight rules. You will learn more about the instrument flight rules in a later lesson. A pilot who elects to fly in accordance with the visual flight rules must be able to maneuver and navigate his aircraft and maintain separation from other aircraft and from terrain by reference to features outside the cockpit. Consequently, VFR flight is possible only when in-flight visibility, cloud base, and separation from cloud meet certain defined minima. These minima are defined as visual meteorological conditions, most often referred to as VMC. VMC minima depend on the class of airspace an aircraft is flying in and the aircraft's altitude or flight level. You will learn more about that later. For the moment, it is sufficient for you to know that when a pilot is flying VFR, he must be in VMC. Flights not conducted in accordance with the visual flight rules must be conducted in accordance with the instrument flight rules. Such flights are commonly referred to as IFR flights. You will learn more about IFR flight later on. For now, it is sufficient to say that, in general terms, instrument flight rules exist to ensure that a pilot has adequate clearance from ground obstacles and that his aircraft is safely separated from other aircraft in the vertical plane, according to the magnetic track being flown. This is done, again, as you will learn later, by assigning different specified cruising flight levels to aircraft depending on whether they are flying on a westerly or easterly track. On screen is a highly simplified representation of this principle. The need for safe separation, whether it be from terrain or from other aircraft, is of course essential when visual meteorological conditions do not prevail and a pilot is required to maneuver and navigate his aircraft by sole reference to instruments. Whenever visual meteorological conditions do not prevail, in other words, where VMC minima are not met, conditions are described as instrument meteorological conditions, more commonly known as IMC. Flight in IMC must be in accordance with the instrument flight rules. Nevertheless, it is important to remember, as we have mentioned before, that IFR flights can take place either in VMC or in IMC. For instance, a commercial airliner flying on international routes in Europe, following airways, will invariably always be flying in accordance with the instrument flight rules for the whole route, irrespective of visibility conditions. That is, irrespective of whether IMC or VMC prevail. One last point for you to note on the instrument flight rules is that IFR flight may apply to flight in both controlled airspace and uncontrolled airspace. The flight crew member, who is responsible in accordance with Annex 2 to the ICAO Convention for ensuring that an aircraft complies with the general rules of the air, as well as with VFR or IFR requirements, is the pilot in command, often referred to in air law terms as the PIC. The pilot in command also has the right to override the rules if it is absolutely necessary to do so for the safety of his aircraft. The Annex 2 ICAO definition of pilot in command is shown on screen here. The pilot in command of an aircraft is the pilot designated by the operator, or in the case of general aviation, the owner, as being in command and charged with the safe conduct of a flight. It is worthwhile citing at this point two other general rules from Annex 2 of the ICAO Convention. Before beginning a flight, the pilot in command of an aircraft must make himself familiar with all available information appropriate to the planned flight. This includes a careful study of current weather reports and forecasts, fuel requirements, and formulating an alternate course of action if the flight cannot be completed as planned. No person is to pilot an aeroplane or act as a flight crew member of an aeroplane whilst under the influence of any psychoactive substance, including alcohol or drugs, by reason of which that person's capacity to act is impaired. That completes the introductory lesson to rules of the air. You learnt in the previous lesson that the rules of the air which apply in any nation state which is an ICAO contracting state will, in general, follow the internationally agreed ICAO standards for rules of the air as laid down in Annex 2 of the Convention on International Civil Aviation. However, you have also learnt that each ICAO contracting state, while undertaking to endeavour to apply the ICAO agreed rules, may interpret the ICAO rules in the context of its own particular requirements. You know too that when any rule of a contracting state's national rules of the air differs from the ICAO rules, that state files a difference with ICAO, and then that state's national rule has precedence over the ICAO rule. In general, then, you will find that, taken as a whole, the rules of the air of any ICAO contracting state in which you fly will be very similar indeed to the rules of any other contracting state. But as a pilot in command, it is your responsibility to be familiar with any national differences and to give those differences precedence over ICAO rules of the air. The Joint Aviation Authorities and the European Aviation Safety Agency are organizations which have undertaken to seek to normalize the aviation regulations of their member states by bringing them into line with ICAO standards. As this computer-based training course is a course for students studying for a JAR FCL pilot's license, the rules of the air taught in this course are the internationally agreed ICAO rules of the air laid down in Annex 2 of the ICAO Convention on International Civil Aviation. Here is the contents page of ICAO Annex 2 Rules of the Air. Scroll through it and take a look at the topics covered. First of all, you will see that Chapter 1 contains definitions of words, expressions, and concepts used in Annex 2. Here is the first page of the ICAO Annex 2 definitions. You must ensure that you learn all these definitions, and be sure too that you always consult the latest edition of ICAO Annex 2. This lesson deals with the subject of the visual flight rules. The visual flight rules, commonly referred to as VFR, are a set of rules which apply to aircraft flight where the pilot is able, at all times, to maintain separation from other aircraft and from terrain by reference to features outside the cockpit. Consequently, VFR flight is permitted only when visibility and separation from cloud meet certain defined minima, which you will learn about later. VFR flight then is not permitted when the minimum required visibility and separation from cloud are not present. In order that you may clearly understand what VFR flight is, it is first of all of some importance that you should be able to distinguish between the two quite different concepts of the visual flight rules, that's VFR, and visual meteorological conditions, most commonly referred to as VMC. Many students confuse VFR with VMC. As student professional pilots, it is important that you do not. Visual meteorological conditions, or VMC, are meteorological conditions expressed in terms of visibility and vertical and horizontal distance from clouds and cloud ceiling, which are equal to or better than specified minima. These VMC minima depend on the class of airspace an aircraft is flying in and the aircraft's altitude or flight level. Illustrated on screen here are the ICAO VMC minima in controlled airspace. When VMC minima are not reached, instrument meteorological conditions, or IMC, are said to prevail. You will learn more about VMC and IMC later on in this lesson. For the moment, just make sure that you remember the following important point. For flight in accordance with the visual flight rules to be permitted, visual meteorological conditions must prevail. But, in addition, the pilot must comply with the provisions of Chapter 4 of Annex 2, which deal with types of airspace, altitudes, speeds, etc. To sum up then, VFR flight must take place in VMC, but the fact that VMC prevails is not in itself sufficient for flight to be permitted in accordance with the visual flight rules. VFR, as the constituent words visual flight rules make clear, is a set of rules governing the conduct of a flight, whereas VMC, visual meteorological conditions, again as the constituent words make clear, are minimum conditions of in-flight visibility and the separation of an aircraft from cloud both horizontally and vertically. For instance, a pilot may be flying at an altitude between 3,000 and 10,000 feet above mean sea level on a beautiful summer's day with limitless visibility, a day which a typical aviator would identify as a day on which visual meteorological conditions obviously prevail. Well, as you will learn later in this lesson, VMC does indeed prevail as long as the pilot does not approach too close to the clouds. If, on this very same beautiful summer's day, the pilot does approach closer to the clouds than the VMC minima prescribe, he will no longer be in VMC, and flight in accordance with the visual flight rules will be illegal. In these sub-VMC conditions, the pilot will be in instrument meteorological conditions and be obliged to continue his flight, if qualified to do so, under the instrument flight rules. The light blue area on screen here delineates the area of sky a pilot must fly in when between 3,000 feet and 10,000 feet above mean sea level in order to remain in visual meteorological conditions. Do not concern yourself for the moment with the actual distances from cloud that the pilot is required to maintain. You'll learn about those later in this lesson. At present, you just need to know that if a pilot were to fly outside the light blue area, he would be closer to cloud than the VMC minima prescribe, and would therefore be in instrument meteorological conditions, in which VFR flight is not permitted. VFR flight is permitted in uncontrolled and in controlled airspace. except in Class A airspace. In the United Kingdom, the London Heathrow Control Zone and Terminal Manoeuvring Area are both Class A airspace, as are all United Kingdom airways. VFR flight in controlled airspace will, on most occasions, except in Class E airspace, be under air traffic control, although often the separation of VFR flights from other flights is not provided by air traffic control, the ATC service being confined to the provision of traffic information. The majority of VFR flights outside controlled airspace take place without any contact with air traffic controllers. Under the visual flight rules, pilots are themselves responsible for their own separation from other aircraft, on the principle of see and be seen. Pilots flying VFR are also responsible for their own separation from the ground. Before passing on to the visual flight rules themselves, let's take a closer look at VMC minima. The visual meteorological conditions minima that we will be examining in this course are those laid down by ICAO. The VMC minima in the airspace over individual nations may be very slightly modified from the ICAO standards, but there should not be any significant difference. In any case, in the JAA ATPL examination, you will be examined on the ICAO figures. Here are the VMC minima for controlled airspace. That's airspace of classes A, B, C, D, and E. Classes of airspace are covered in a separate lesson. Above 10,000 feet, or above flight level 100 if the transition altitude is below 10,000 feet, VMC minima in controlled airspace require the pilot to have an in-flight visibility of at least 8 kilometers, and to be able to maintain vertical separation from cloud of at least 1,000 feet, and horizontal separation from cloud of at least 1,500 meters. Use your pause button if you wish to remain on this frame. Below 10,000 feet, or below flight level 100 if the transition altitude is lower than 10,000 feet, VMC minima in controlled airspace require the pilot to have an in-flight visibility of at least 5 kilometers, and to be able to maintain vertical separation from cloud of at least 1,000 feet, and horizontal separation from cloud of at least 1,500 meters. Here are the VMC minima for uncontrolled airspace. That's airspace of classes F and G. Classes of airspace are covered in a separate lesson. Above 10,000 feet, or above flight level 100, if the transition altitude is below 10,000 feet, VMC minima in uncontrolled airspace require the pilot to have an in-flight visibility of at least 8 kilometers, and to be able to maintain vertical separation from cloud of at least 1,000 feet, and horizontal separation from cloud of at least 1,500 meters. You will notice that these VMC minima above 10,000 feet or above flight level 100 in uncontrolled airspace are the same as for the VMC minima in controlled airspace above that level. Use your pause button if you wish to remain on this frame. The next level we must consider in uncontrolled airspace is that below 10,000 feet, or flight level 100, but above 3,000 feet, measured with respect to mean sea level. In this level band, VMC minima in uncontrolled airspace require the pilot to have an in-flight visibility of at least 5 kilometers, and to be able to maintain vertical separation from cloud of at least 1,000 feet, and horizontal separation from cloud of at least 1,500 meters. Again, use your pause button if you wish to remain on this frame. Finally, in uncontrolled airspace, we must look at the airspace from the surface up to 3,000 feet above mean sea level, or up to 1,000 feet above terrain, whichever is the higher. In this lower band of airspace, a pilot is flying in VMC if he is clear of cloud, in sight of the surface, and has an in-flight visibility of 5 kilometers. In some ICAO signatory states, the in-flight visibility required for VMC to prevail in this lower band of airspace may be reduced to below 5 kilometers by the National Aviation Authority if an aircraft's airspeed does not exceed a given maximum value. For instance, in the United Kingdom, for aircraft flying at less than 140 knots, VMC minima require a pilot to have a forward visibility of only 1,500 meters. Even here, though, pilots must be aware of the restrictions attached to basic licenses. For example, in the United Kingdom, no holder of a basic private pilot's license who does not also possess an instrument qualification may fly at all if the forward visibility is less than 3 kilometers. So in the UK, the restrictions of a basic private pilot's license do not allow a light aircraft pilot to fly in VMC minima. You may wish to spend a few moments pondering over this apparent paradox. Now let us look at the visual flight rules themselves. They are contained in Chapter 4 of ICAO Annex 2. Here's the actual page from Annex 2 on which the VFR rules are contained. If you wish, you may scroll through the page to look at the rules yourself. But if you are referring to the visual flight rules for operational purposes, or before taking an examination, make sure that you consult the latest edition of Annex 2. The first and most fundamental VFR rule is the one that you have already learnt. That is, that VFR flights must be conducted so that the aircraft is flown in conditions of visibility and distance from clouds equal to or greater than VMC. The picture on screen depicts visual meteorological conditions in uncontrolled airspace above 3,000 feet but below 10,000 feet, or flight level 100 if the transition altitude is lower than 10,000 feet. The details of this rule have already been covered in this lesson. This image depicts VMC for all of uncontrolled airspace. Here are the VMC minima again, this time for controlled airspace. Remember that no VFR flight is permitted in Class A airspace, such as the London Heathrow Control Zone, or in any United Kingdom airway. In certain circumstances, for flight in aerodrome control zones, a special VFR clearance may be obtained from air traffic control, which permits a non-instrument qualified pilot to fly in the control zone in lower than normal VMC minima. You will learn about special VFR flight in a later lesson. Now let us look at the rules covering the VMC minima requirement for VFR flight in control zones. Unless special clearance is obtained, flights operating in accordance with the visual flight rules are not permitted to take off or land or operate within the air traffic zone of an aerodrome with a control zone when meteorological conditions are below specified minima. Those weather minima stipulate that the cloud ceiling must not be less than 1,500 feet, and the ground visibility must not be less than 5 kilometers. There are different rules in different nations covering VFR flight at night. The actual definition of night also varies from nation to nation. The International Civil Aviation Organization defines night as the period from the end of evening civil twilight to the beginning of morning civil twilight. Civil twilight is defined as the period between sunset or sunrise and the time when the center of the sun's disk is 6 degrees below the horizon. As far as VFR flight at night is concerned, ICAO Rules of the Air state simply that VFR flights at night may be permitted as laid down by the appropriate National Aviation Authority. For example, the United Kingdom defines night as stretching from 30 minutes after sunset to 30 minutes before sunrise. And in the United Kingdom, VFR flight at night is not permitted. All night flying in the United Kingdom must therefore be conducted in accordance with the instrument flight rules. Although pilots do not need to possess an instrument rating to fly at night in the United Kingdom, they must, however, hold a night qualification. Let's now look at how altitude or flight level affects the right to fly in accordance with the visual flight rules. Unless authorized by the appropriate Air Traffic Services Authority, VFR flights are not to take place above flight level 200. Incidentally, VFR flight may not be conducted at transonic or supersonic speeds at any level or altitude. Authorization will on no account be given for VFR flights to operate above flight level 290 in areas where a vertical separation minimum of 1,000 feet or 300 meters is in effect above that flight level. We'll now take a look at the VFR low flying rule. Except where necessary for takeoff or landing, or except by permission from the appropriate Air Traffic Services Authority, an aircraft is not to operate in accordance with the visual flight rules at a height of less than 1,000 feet, that's 300 meters, above the highest obstacle within a radius of 600 meters from the aircraft. Neither may an aircraft operating VFR fly at less than 1,000 feet over settlements, towns, cities, or other congested areas, or at less than 1,000 feet over an open-air assembly of persons. Never forget, though, that adherence to the VFR low-flying rule does not absolve a pilot from the absolute minimum height rule, which requires the pilot, unless he is landing or taking off, never to fly below a height from which he can safely land his aircraft, in the event of an emergency, without causing undue hazard to persons or property on the ground. Elsewhere than over congested areas or open-air assemblies of persons, a VFR flight is not to operate at a height of less than 500 feet, that's 150 meters, above the ground or water. Now we'll look at the ICAO rule regarding VFR cruising flight levels. Except where otherwise authorized by an Air Traffic Services Authority, ICAO Rules of the Air require that aircraft in level cruising flight higher than 3,000 feet above the ground or water, which are operating in accordance with the visual flight rules, to keep to specified flight levels dependent on their magnetic track. The relationship between available VFR flight levels and magnetic track is governed by what is called the semicircular rule, so called because the assigned flight levels distinguish between aircraft flying on magnetic tracks between 0 and 179 degrees and those on magnetic tracks of between 180 and 350 1.59 degrees. You can see on screen here the principle of the semicircular rule for VFR flight. Here the rule is expressed in the form of a table. Notice that ICAO assigns separate flight levels to VFR and IFR flights within the semicircular principle. Some states, such as the United Kingdom, do not apply the ICAO semicircular rule outside controlled airspace. For instance, in uncontrolled airspace in the United Kingdom, IFR traffic in level cruising flight above the transition altitude operate in accordance with the quadrantal rule depicted on screen here. VFR traffic in the United Kingdom are not obliged to keep to this rule, though they are recommended to do so. However, the semicircular rule does apply in the United Kingdom to IFR traffic above the transition altitude in controlled airspace, unless air traffic control instructs otherwise. In the JAA ATPL Air Law examination, you will be tested on the ICAO rule only. VFR flight in controlled airspace is also covered by the rules of the air. VFR flights operating within airspace classes B, C and D, which will normally comprise control zones and control areas, when forming part of aerodrome traffic or operating as special VFR flights, must operate in accordance with the air traffic control requirements detailed in the rule of the air known as Rule 3.6. Rule 3.6 provisions basically stipulate that the VFR flight must obtain an air traffic control clearance and maintain a continuous air-ground voice communication watch on the appropriate communication channel. A VFR flight operating along advisory routes or across international borders or along other routes designated by the appropriate Air Traffic Services Authority must also maintain a continuous air-ground voice communication watch on the appropriate communication channel and report its position as necessary. If an instrument-qualified pilot is flying in accordance with the visual flight rules in uncontrolled airspace, and the weather deteriorates from visual meteorological conditions to instrument meteorological conditions, the pilot must continue the flight by switching to the instrument flight rules. You will learn what those rules are in the next lesson. Note that a non-instrument qualified pilot must at all times remain in visual meteorological conditions. However, if an appropriately qualified pilot wishes to or is obliged to change from the visual flight rules to the instrument flight rules, he must take the following action. If a flight plan has been submitted, the pilot must communicate to the appropriate Air Traffic Services Unit the necessary changes to be effected to his current VFR flight plan. The pilot of an aircraft receiving an air traffic control service, who changes from the visual flight rules to the instrument flight rules, must submit by radio his modified flight plan to the appropriate Air Traffic Services Unit, and, if in controlled airspace, be sure to obtain a clearance prior to proceeding in accordance with the instrument flight rules. It is appropriate at this point to consider the rules of the air which govern flight in the proximity of aerodromes. The pilot of an aircraft operating at or in the vicinity of an aerodrome, whether or not he is within the aerodrome traffic zone itself, is required to conform with several rules. He must observe other aerodrome traffic for the purpose of avoiding collision. He must conform with or avoid the pattern of traffic formed by other aircraft operating at the aerodrome. He must make all turns to the left when approaching for a landing and after taking off, unless a right-hand circuit pattern is in force, or unless otherwise instructed. He must land and take off into the wind, unless safety, the runway configuration, or air traffic considerations determine that a different direction is preferable. That completes the lesson on the visual flight rules. As a final reminder, take care not to confuse visual flight rules with visual meteorological conditions. VFR is a set of rules, whereas VMC describes meteorological conditions defined in terms of visibility and distance from cloud. Flights in accordance with the visual flight rules must be conducted in visual meteorological conditions. However, flights conducted in accordance with the instrument flight rules are very often also conducted in visual meteorological conditions. Instrument flight rules are, like the visual flight rules, rules governing the conduct of an aircraft in flight. You will learn about the instrument flight rules in the next lesson. In this lesson, you will learn about the instrument flight rules. Expressed simply, the instrument flight rules, commonly referred to as IFR, are a set of rules for flights during which it cannot be assumed that pilots will be able to navigate their aircraft or maintain separation from obstacles, terrain, and other aircraft by reference to features outside the cockpit. So, in general terms, instrument flight rules exist to ensure that a pilot has adequate clearance from ground obstacles and that his aircraft is safely separated from other aircraft in the vertical plane. For flight in accordance with the instrument flight rules, navigation and obstacle clearance must be able to be maintained by sole reference to the aircraft's instruments. And under the instrument flight rules, separation of aircraft from other air traffic is provided either by pilots receiving an air traffic control service or by aircraft flying at specified flight levels depending on their magnetic track over the ground. You should note that whereas all flights which take place in instrument meteorological conditions must be conducted in accordance with the instrument flight rules, flight under the instrument flight rules may also take place in visual meteorological conditions. Instrument flight rules are, as their name makes clear, a set of rules governing the conduct of an aircraft in flight. The instrument flight rules are quite independent of the prevailing meteorological conditions. So even though the instrument flight rules assume that separation from terrain and other aircraft can not be maintained by reference to features outside the cockpit, and that the aircraft is being operated by sole reference to its instruments, the instrument flight rules may still be followed or imposed even in visual meteorological conditions. In fact, most commercial air transport flights within Europe and the United States are under continuous air traffic control, and therefore operate within controlled airspace under instrument flight rules for the whole flight, irrespective of whether visual meteorological conditions or instrument meteorological conditions prevail. Now that you have learnt about the concept of instrument flight rules, let's pass on to the rules themselves. Here they are, as contained in Chapter 5 of Annex 2 to the Convention on International Civil Aviation. Scroll through the instrument flight rules and note that they take up scarcely more than one page. When referring to Annex 2 for operational or examination purposes, always ensure that you consult the very latest version of the Annex. In order to be able to fly in accordance with the instrument flight rules, aircraft must be equipped with suitable instruments and with navigation equipment appropriate to the route to be flown. Flight in accordance with the instrument flight rules must not be conducted at a level which is below the minimum flight altitude for IFR flight established by the nation whose territory is being overflown. Where a nation has not established a minimum IFR flight altitude, the ICAO minimum level rules apply. These are that an aircraft flying in accordance with the instrument flight rules over mountainous areas or high terrain is to remain at least 2,000 feet or 600 meters above the highest obstacle located within 8 kilometers of the estimated position of the aircraft. Elsewhere than over high terrain or mountainous areas, IFR flights are to remain at least 1,000 feet or 300 meters above the highest obstacle located within 8 kilometers of the estimated position of the aircraft. For the purpose of adhering to the IFR minimum level rules, the estimated position of the aircraft must take account of the navigational accuracy which can be achieved on the relevant route segment, having regard to the navigational facilities available in the aircraft and on the ground. Pilots should note that IFR minimum level rules do not absolve them from the necessity to adhere at all times to the overall minimum height rule, which stipulates that an aircraft must not be flown over congested areas or over an open-air assembly of persons below a height that, in the event of an emergency arising, would enable the aircraft to make a landing without undue hazard to persons or property on the surface. The only exceptions to all the minimum level rules just mentioned are when an aircraft is taking off or landing, or when specifically authorized to descend below the established minimum levels by the appropriate authority. In the lesson on the visual flight rules, you learnt about the rules governing the procedure for changing from VFR flight to IFR flight. You will not be surprised to learn that similar rules exist to cover the situation where a pilot wishes to, or is obliged to, change from the instrument flight rules to the visual flight rules. If he has submitted a flight plan, a pilot who elects to change the conduct of his flight from compliance with the instrument flight rules to compliance with the visual flight rules must tell the appropriate air traffic services unit that the IFR flight plan is cancelled and communicate to that air traffic services unit the changes to be made to the existing flight plan. When the pilot of an aircraft operating under the instrument flight rules wishes to cancel his IFR flight plan because he has encountered visual meteorological conditions, he must not cancel the IFR flight plan unless he anticipates and intends that the flight will be continued for a reasonable period of time in uninterrupted visual meteorological conditions. When operating in accordance with the instrument flight rules in controlled airspace, the IFR flight is known as a controlled flight, and an air traffic control clearance is required for the flight to take place. The required air traffic control clearance is requested by the pilot by submitting a flight plan to the appropriate air traffic services unit. When operating in controlled airspace, IFR flights must comply with air traffic control instructions and with all the sections of Rule of the Air 3.6. Rule of the Air 3.6 deals with controlled flights, air traffic services, air traffic control clearances, adherence to flight plans, and communications. Rule of the Air 3.6 is covered by separate lessons in this CBT course. Unless otherwise instructed by air traffic control or approved in an ATC clearance, when an aircraft operating in accordance with the instrument flight rules is in cruising flight within controlled airspace, the aircraft is to be flown at a cruising flight level dependent on the aircraft's magnetic track over the ground. An indication of the correlation between cruising flight levels and magnetic track for IFR flight is shown on screen here. Note that different cruising flight levels are allocated for IFR and VFR flights. The rule governing the correlation between cruising levels and magnetic track is semicircular in nature, because approximately half of the allocated flight levels are for aircraft in the cruise on magnetic tracks from 0 degrees to 179 degrees, while the remaining allocated flight levels are for aircraft in the cruise on magnetic tracks from 180 degrees to 359 degrees. The semicircular nature of this rule is illustrated here. You can see that from 0 to 179 degrees, IFR cruising levels are at odd-numbered flight levels, while from 180 to 359 degrees, the IFR cruising levels are even-numbered flight levels. If an aircraft is authorized to employ cruise climb techniques between flight levels, the higher flight level at which the aircraft levels off must also be in compliance with this so-called semicircular rule. The cruising levels that we have just illustrated are to give you merely an idea of the full table of cruising levels. That table is contained at Appendix 3 to Annex 2 of the ICAO Convention on International Civil Aviation. Be sure to refer to Annex 2 in order to study the details of this rule. We show an extract from Appendix 3 to ICAO Annex 2 here. Be sure, though, to refer to the latest edition of Annex 2 when using the table for operational or examination purposes. The cruising flight level rule that you have just learnt about also applies to IFR flights operating in uncontrolled airspace, except when otherwise specified by the appropriate Air Traffic Services Authority for flight at or below 3,000 feet above mean sea level. An aircraft operating in accordance with the instrument flight rules outside controlled airspace is not always obliged to maintain an air-ground voice communication watch with an air traffic services unit. However, if outside controlled airspace, but within advisory airspace, or when otherwise so required by the appropriate Air Traffic Services Authority, an IFR flight is to maintain an air-ground voice communication watch on the appropriate communication channel and establish two-way communication as necessary with the Air Traffic Services Unit. This situation is amplified by the rules of the air shown on screen here. The pilot of an IFR flight operating outside controlled airspace, but who is required by the appropriate Air Traffic Services Authority to submit a flight plan and to maintain an air-ground voice communication watch with an Air Traffic Services Unit, for instance, an IFR flight within advisory airspace, is required to report his position as specified in Rule of the Air 3.6.3, applicable to controlled flights. That completes the lesson on the instrument flight rules. The general rules of the air are contained in Chapter 3 of Annex 2 to the ICAO Convention. You can see the contents of Chapter 3 here. Of the principal rules of the air headings that you see, the most important will be covered by separate lessons in this Rules of the Air section of the Air Law CBT course. But before taking your examination in Air Law, make sure that you read through Chapter 3 for yourself and satisfy yourself that you are familiar with its details. In this lesson, we will cover the rules of the air dealing with minimum height, cruising levels, and avoidance of collisions, both in the air and on the ground. The first part of Chapter 3, Annex 2, deals with the protection of persons and property. As you see, the key statement here is that an aircraft is not to be operated in a negligent or reckless manner so as to endanger the life or property of others. One of the central tenets of this rule is that there is a minimum height below which aircraft may not be flown. The ICAO minimum height rule states that, except where necessary for takeoff or landing, or except when express permission is given by the appropriate authority, an aircraft may not be flown over the congested areas of cities, towns, or settlements, or over an open-air gathering of people, unless the aircraft is at such a height that will permit it, in the event of an emergency arising, to make a landing without causing undue hazard to persons and property on the ground. This general minimum height rule should not be confused with the minimum specified height rules applied to IFR or VFR flight. You have learnt about minimum heights for VFR and IFR flight in the previous two lessons. But because aircraft are always flying in accordance with either the instrument flight rules or the visual flight rules, you may ask yourself how you reconcile those rules with the general minimum height rule just quoted. The answer is straightforward. The minimum height we can fly is that which satisfies both the general rule and the rules that apply to our type of flight, that is, VFR or IFR, except of course for the purpose of takeoff and landing, or with authority permission to do otherwise. Now let's move on to the question of cruising levels. You should note here that the word level used generally in air law refers to height, altitude, or flight levels. However, in this lesson we will be talking about either altitudes on the one hand or flight levels on the other. In order to meet air traffic and flight safety requirements, national aviation authorities establish one or more transition altitudes in the state or states for which they are responsible. At or below the relevant transition altitude, the vertical position of an aircraft in the cruise is monitored and reported by reference to altitude. Altitude is measured with respect to the local sea level pressure setting, which is known throughout the world of aviation as QNH. Over countries whose topography includes high ground and mountains, the transition altitude will be higher than over a low-lying country. For example, in the United Kingdom, the transition altitude is generally 3,000 feet, with certain exceptions such as around Heathrow and Glasgow. In the United States, though, the transition altitude over most of the country is 18,000 feet, while in New Zealand the transition altitude is 13,000 feet. Above the relevant transition altitude, the air traffic services monitor and pilots report the vertical cruising position of aircraft by reference to flight levels. Flight levels are measured with respect to a standard pressure setting of 1013.2 hectopascal or millibars. The lowest usable flight level above the transition altitude is called the transition level. You should note that while a transition altitude is set by a national aviation authority, transition levels are not fixed, but change with changing atmospheric pressure. So, on a given day, the transition level might be flight level 45, for instance, as shown here, or, as in this example, flight level 40. The phenomenon of changing values for the transition level can be awkward to understand. You should take time to study the phenomenon on your own by referring to the lesson on altimetry in the subject of meteorology. Now let's move on to avoidance of collision. In all aircraft operations, it is of supreme importance that rules be established to help keep the risk of collision between aircraft to an absolute minimum, whether the aircraft are in the air or on the ground. When aircraft are under radar control and flying in accordance with the instrument flight rules, collision avoidance is the responsibility of the air traffic controller as well as that of the pilot. And so the rules of the air on collision avoidance may seem to apply predominantly to aircraft flying in accordance with the visual flight rules. Nevertheless, collision avoidance rules must be observed and put into practice by all pilots. It is crucial that flight crew never relax their vigilance in seeking to avoid collisions between aircraft in flight, regardless of the type of flight, or of the class of airspace in which the aircraft is operating. Vigilance of flight crew on the ground is also of great importance. One of the most fundamental rules of collision avoidance is the proximity rule. That rule states that an aircraft is not to be operated in such proximity to other aircraft as to create a collision hazard. This, of course, is the reason why aircraft are not to be flown in formation, except by prearrangement between the pilots in command of the aircraft taking part in the flight. If the formation flight is to take place in controlled airspace, the flight must be in accordance with the conditions prescribed by the appropriate air traffic services authorities. It is in order to help ensure that collisions between aircraft do not occur that rules concerning rights of way have been established. In all rules pertaining to right of way, the aircraft which has the right of way maintains its heading and speed. However, it is crucial that pilots understand that no right of way rule relieves the pilot in command of an aircraft having the right of way from the responsibility of taking avoiding action should it prove necessary. The pilot of the aircraft required to give way may not have seen the other aircraft. It can easily be fatal in the air for a pilot to insist on his priority. It is incumbent on all pilots to take action to avoid collision. This principle includes action to avoid collision based on resolution advisories provided by ACAS equipment. ACAS is the Airborne Collision Avoidance System, equipment that seeks to warn pilots of the proximity of other aircraft. The remainder of this lesson deals with specific rules of the air from Chapter 3 of ICAO Annex 2, which pertain to avoidance of collision and rights of way. An aircraft which is obliged by the rules which follow to keep out of the way of another aircraft must avoid passing over, under, or in front of the other aircraft unless passing well clear. Aircraft taking avoiding action must also take into account the effect of wake turbulence. If two aircraft are approaching head-on and there is a danger of collision, both aircraft are to alter heading to the right. It is generally accepted that anything within the sector 20 degrees either side of dead ahead is head-on. This is particularly important nowadays as navigation equipment is so accurate that it will place aircraft exactly on the center line of airways. All it takes is an incorrect flight level assignment or poor height keeping, and a head-on situation is much more likely to occur than it used to be. When two aircraft of the same category, for instance, two powered heavier-than-air aircraft, are converging at approximately the same level, the aircraft which has the other aircraft on its right is to give way. Expressed simplistically, the aircraft on the right is in the right and should maintain speed and heading. Where the converging aircraft are not of the same category, being on the right does not automatically give that aircraft the right of way. In the case of different categories of aircraft, the following right-of-way rules apply. Power-driven, heavier-than-air machines are to give way to airships, balloons, and gliders. Power-driven, lighter-than-air machines, for instance airships, are to give way to gliders and balloons. Gliders are to give way to balloons. Power-driven aircraft are to give way to aircraft which are towing other aircraft or objects. Here is a summary of the right-of-way rules in the air when aircraft are converging. Never insist on your right-of-way. Even if you have the right-of-way, always be prepared to take avoiding action yourself if the other aircraft does not. Now let's look at the situation of overtaking. An overtaking aircraft is a faster aircraft that approaches another aircraft from behind, within a 70-degree arc either side of the tail of the aircraft being overtaken. At night, the overtaking aircraft in this position would be unable to see either of the other aircraft's port or starboard navigation lights. It is the aircraft which is being overtaken that has the right of way. The overtaking aircraft, whether climbing, descending, or in horizontal flight, must keep out of the way of the other aircraft by altering its heading to the right. The overtaking aircraft must stay out of the way of the aircraft being overtaken until well clear. Furthermore, the pilot of the overtaking aircraft should take into account the wake turbulence which might possibly affect his own aircraft or the aircraft being overtaken during the overtaking maneuver. Now let's move on to the question of priority on landing. An aircraft in flight or operating on the ground or water is required to give way to aircraft landing or in the final stages of an approach to land. When two or more heavier-than-air aircraft are approaching an aerodrome for the purpose of landing, aircraft at the higher level must give way to aircraft at the lower level. But the lower aircraft must not take advantage of this rule to cut in front of another aircraft which is in the final stages of an approach to land, or to overtake that aircraft. In any event, power-driven, heavier-than-air aircraft are to give way to gliders. An aircraft whose pilot is aware that another aircraft is compelled to land because of an emergency must give way to that aircraft. Let's pass now to the issue of priority on takeoff. An aircraft taxiing on the maneuvering area of an aerodrome must give way to aircraft taking off or about to take off. Chapter 3 also contains rules governing the surface movement of aircraft. An aircraft taxiing on the maneuvering area must stop and hold at all runway holding positions, unless otherwise authorized by air traffic control. Likewise, an aircraft taxiing on the maneuvering area must stop and hold at all lighted stop bars, such as those shown here at a taxiway intersection. The aircraft may proceed further only when the lights are switched off. If there is any danger of collision between two aircraft taxiing, the following collision avoidance rules apply. When two aircraft are approaching head-on, or approximately so, each aircraft must stop, or, where practicable, alter its course to the right, so as to keep well clear. When two aircraft which are taxiing are converging, the one which has the other on its right must give way. Any aircraft which is being overtaken by another aircraft has the right of way. The overtaking aircraft must keep well clear of the aircraft being overtaken. That completes the lesson on minimum height, cruising levels, and avoidance of collisions.
The systems of displaying aeroplane, navigation and anti-collision lights, or any other lights designed to draw attention to the presence of an aeroplane, are covered in other lessons. But you may be asked questions on the subject in the ATPL Air Law exam. To this end, Air Law restricts itself to when you must have the lights fitted and when they must be on. From sunset to sunrise, as defined by the authority, aeroplanes are to be illuminated with anti-collision lights, intended to attract attention to the aeroplane. Additionally, navigation lights that define the relative path of the aeroplane are to be displayed. No other light can be shown if it is likely to be mistaken for these lights. If aeroplanes have anti-collision lights fitted, they should be on by day as well. Aeroplanes should not land specifically for the purpose of repairing broken anti-collision lights. From sunset to sunrise, all aeroplanes moving on the movement area shall display navigation lights that indicate the relative path of the aeroplane. All aeroplanes on the movement area shall display lights that define the extremities of their structure, unless stationary and otherwise adequately illuminated. Aeroplanes parked on an apron will be adequately illuminated because the apron is required to be lit at night. Away from an apron, aeroplanes must be lit. All aeroplanes on the movement area of an aerodrome are to display lights that attract the attention of other aeroplanes. Aeroplanes with engines running are to display lights to indicate the fact. Red anti-collision lights suffice for this purpose. In fact, it is usual to switch on the anti-collision lights when an aircraft is manned to indicate the fact and serve to warn that the engine may be started. A pilot is permitted to switch off or dim the intensity of any flashing light if they are likely, in his opinion, to adversely affect the satisfactory performance of his duty, or subject an outside observer to harmful dazzle. A flight plan is the means by which an ATSU is notified of your intentions to fly, and, where necessary, to request clearance to fly as a controlled flight. A flight plan is to be submitted prior to operating any flight or portion thereof to be provided with an air traffic control service, or any IFR flight within advisory airspace, or any flight within or into designated areas or along designated routes, when so required by appropriate ATS authorities to facilitate the provision of flight information, alerting and search and rescue services, or any flight within or into designated areas or along designated routes, when so required by the appropriate ATS authority to facilitate coordination with appropriate military units or with air traffic service units in adjacent states, in order to avoid the possible need for interception for the purposes of identification. An example of this is to coordinate with the controllers of the air defense interception zones the USA has offshore of its east and west coastlines, or any flight across international borders, not just FIR boundaries. A flight plan should be submitted before departure to an ATS reporting office, Flight Planning Section, Ops Room, ATC or FIS office, or during flight, transmitted to the appropriate ATS unit or air-to-ground control radio station, unless arrangements have been made for the submission of repetitive flight plans. Unless otherwise required by the ATS authority, a flight plan is to be submitted at least 60 minutes before departure, or if submitted in flight, at a time that will ensure its receipt by the appropriate ATSU, at least 10 minutes before the aircraft is estimated to reach the intended entry point to a control area or advisory area, or the point of crossing an airway or advisory route. A flight plan is to contain the following as considered relevant by the appropriate ATS: aircraft identification, flight rules and type of flight, number and type of aircraft and wake turbulence category, equipment, departure aerodrome and estimated off-blocks time, EOBT, for a flight plan submitted in the air. These items should be a place where the ATSU can obtain more information about the flight, and the time should be the first time an air traffic control or advisory service is required. Cruising speeds, cruising levels, route to be followed, destination aerodrome and total elapsed time, alternate aerodrome, fuel endurance, total number of persons on board, emergency and survival equipment, other information. With the exception of inadvertent deviations from planned flight, all changes to a flight plan submitted for IFR flight or a VFR flight operated as a controlled flight are to be reported as soon as practicable to the appropriate Air Traffic Services unit. For other VFR flights, significant changes to flight plans should be reported as soon as practicable to the appropriate ATSU. Closing a flight plan, arrival plan, is to be done in person by radio or data link, as soon as possible after landing, to the appropriate ATSU at the arrival aerodrome, for any flight or portion of flight for which the flight plan has been submitted. On receipt of the arrival report, the ATSU will close the flight plan. When communication facilities are known to be inadequate, and alternative message handling facilities do not exist, a message comparable to an arrival report is required. Failure to comply with these provisions may cause serious disruption of air traffic services, and is likely to incur great expense in carrying out unnecessary SAR operations. An arrival report is to contain the following: aircraft identification, departure aerodrome, destination aerodrome, arrival aerodrome, time of arrival. Destination aerodrome is only included, of course, if it is not the arrival aerodrome. In other words, the aircraft has been diverted. Coordinated universal time is to be used, and is to be expressed in hours and minutes using the 24-hour clock, beginning at midnight. Time checks by ATC are given accurate to the nearest minute. An ATC clearance is to be obtained prior to operating a controlled flight, or a portion of a flight as a controlled flight. Such a clearance can be requested by the submission of a flight plan to an ATCU. A pilot in command may request an amended clearance if the one issued is unsatisfactory, and as such, an amended clearance will be issued if practicable. It would be normal practice for a clearance to be passed to the aircraft before departure, and at busy aerodromes, a discrete clearance delivery frequency is specifically established for the issue of ATC clearances. Before passing the pilot a clearance, you will be asked, "Ready to copy?" When ready, your response will be, "Go ahead." The clearance will be read to you, and when terminated, you will be asked to read back. You are required to read back the clearance verbatim. If you make an error, you will be asked to repeat the process until you correctly read back the clearance. This ensures that you completely understand the issued clearance. Don't forget that air traffic controllers are fallible, so if you believe that there is an error in your clearance, then query it. Flight plans are to be adhered to unless an emergency situation occurs which necessitates immediate action by the aircraft. In such a case, the ATSU is to be informed as soon as possible. Controlled flights are required to operate along the centerline of an airway or route directly between beacons, if that is how the route is specified. If a controlled flight inadvertently deviates from its current flight plan, the following action is to be taken. Deviation from track must result in actions to immediately regain track. Variation in TAS by more than ±5% of TAS specified in the flight plan must result in the notification of the ATC. Changes in ETA that result in more than 3 minutes being added to arrival times at reporting points or FIR boundaries must be communicated to the ATC. Weather deterioration below VMC that prevents maintenance of a running flight plan clearance must result in the requesting of a new flight plan or the following of a new routing that allows accommodation of the new VFR flight conditions. Unless advised to cease position reporting by an ATCU, pilots of aeroplanes on controlled flights are to make position reports as soon as practicable after reaching that point. The report is to contain the aircraft identification, the aircraft's position, the time, the flight level of passing the point, the aeroplane's next position and estimated time of arrival, any other information deemed necessary. If SSR Mode C has been verified by the ATCU as accurate, then flight level reports may be omitted. A controlled flight is to advise the appropriate ATCU as soon as it ceases to be subject to air traffic control services. This will be done automatically as soon as an aircraft lands at a controlled aerodrome. In the event of communications failure, aircraft operating in accordance with ATC clearance, where two-way radio communication is required, are to comply with the requirements of ICAO Annex 10, Telecommunications, Volume 2. This specifies the requirement for air-to-ground communications equipment and the radio frequencies allocated to the aeronautical telecommunications network. If the communication system of an aeroplane, receiver or transmitter, fails when the aeroplane is flying in the traffic pattern of a controlled aerodrome, a visual watch shall be maintained, and instructions will be issued by visual signals. If failure occurs during flight in VMC, regardless of flight rules, the aeroplane is to continue to fly VMC, land at the nearest suitable aerodrome, and report its arrival by the most expeditious means to the appropriate ATCU. If failure occurs in IMC and the airspace is not under radar control but is controlled procedurally, the following are to be complied with. 1. Unless prohibited by a regional air navigation agreement, the aircraft is to maintain its last assigned speed and level, or minimum flight altitude if higher, for a period of 20 minutes following the aircraft's failure to report over a compulsory reporting point, and thereafter adjust level and speed in accordance with the filed flight plan. 2. Proceed according to the current flight plan route to the appropriate designated navigation aid serving the destination aerodrome, and, when required, hold over this aid until commencement of descent. 3. Commence descent from the nav aid at or as close to the expected approach time EAT last received and acknowledged. If no EAT has been received and acknowledged, descend at or as close as possible to the ETA resulting from the current flight plan. 4. Complete a normal instrument approach procedure as specified for the designated aid. And 5. Land if possible within 30 minutes after the ETA or the last acknowledged EAT, whichever is later. In airspace under radar control, as in the case over Europe, the IMC procedure differs slightly. Here, the flight should remain at its last assignment for only 7 minutes, until reverting to flight plan. This is because, with radar monitoring, the 7600 squawk should be noticed quickly. The 7 minutes is based upon the latest of the following times: the time the aircraft reached its assigned level, or, if there was no assignment before the radio failed, the time the minimum flight altitude was reached, the time 7600 was set, the time the crew were unable to report position over a compulsory reporting point. The remainder of the procedure is the same as the IMC and non-radar airspace SOP, discussed previously. Where an aircraft is being subject to unlawful interference, for example a hijack, communication with the appropriate ATC authority is to be attempted. This will enable the authority to give priority to the aircraft and deconflict other air traffic in the event of deviation from any flight plan. Specifically, unless conditions dictate otherwise, the PIC is to attempt to continue to fly the assigned track at the assigned level, at least until able to notify an ATSU or until within radar coverage of a radar unit. If forced to deviate from an assigned track or level without being able to notify an ATSU, the PIC should, if possible, attempt to broadcast a warning on the VHF emergency frequency 121.5 MHz and use other onboard alerting equipment such as SSR on mode alpha 7500 or data links, proceed in accordance with applicable alerting procedures for in-flight contingencies established and published in document 7030 regional supplements. If no regional procedures have been established, proceed at a level different from IFR levels by 1,000 feet above flight level 290 or 500 feet below flight level 290, or when reduced vertical separation minima, RVSM, are used. Under Article 9 of the Convention on Civil Aviation, each contracting state has the right, for the reasons of military necessity or public safety, to prohibit the aircraft of other states from flying over certain areas of its territory, and to establish procedures for the interception of aircraft flying over that territory. Ultimately, the regulations of a state may prescribe the need to investigate and identify an aircraft. Thus, it may become necessary to lead an aircraft of another state away from a particular area, or require it to land for security reasons at a designated aerodrome. Adherence to flight plans and maintaining a listening watch on the appropriate air traffic frequencies make the possibility of interception extremely rare. In formulating such policies, states are to recognise that to ensure general safety in the air, any visual identification signals are to be made in accordance with Appendix 1 to Annex 2 of the Chicago Convention. This lays down standard rules for intercepting aircraft and mandates that intercepted aircraft are to comply with the standards set out in the Appendix 2, Section 2 and 3 to Annex 2, interpreting and responding to visual interception signals. If the identity of an aircraft is in doubt, all possible efforts will be made to secure the identification through the appropriate air traffic authorities. As intercepting civil aircraft is potentially hazardous, the intercepting procedure is to be used as a last resort. An intercepted aircraft shall immediately follow the instructions being given by the intercepting aircraft, notify, if possible, the appropriate air traffic service unit, attempt to establish radio communication with the intercepting aircraft or with the appropriate intercept control unit by making a general call on the emergency frequency 121.5 MHz, giving the identity of the intercepted aircraft and the nature of the flight. If this frequency elicits no response, calls should be made on 243 MHz in an attempt to establish contact. If equipped with SSR, then select Mode A, code 7700, or any other code that you are instructed to. If radio contact is established with the intercepting aircraft, but communication in a common language is not possible, attempts should be made to convey essential information and acknowledgement of instructions by using the phrases and pronunciations shown in the table. It is a requirement of international law that aircraft engaged on international flights must carry the interception tables. Clearly, the intention is that if intercepted, one can refer to the tables. An aircraft is considered to be in a state of distress when it is in grave and imminent danger and requests immediate assistance. The pro word for such a call for help is Mayday. The visual signals are Morse code signals SOS, a succession of red pyrotechnics, and a red parachute flare. The sound signals are Morse code signals SOS, continuous sounding with any apparatus, radio telegraph and radio telephone signals consisting of 12 dashes of 4 seconds each, with a pause of 1 second between each one, sinusoidal audio tones of 2200 Hz and 1300 Hz, with each tone duration of 250 milliseconds. This alarm sent automatically for a duration of at least 30 seconds, but not more than 1 minute. If an aircraft has an urgent message to transmit regarding the safety of itself, other aircraft, vehicles, or other property of a person on board or within sight, then the message is classified as being urgent. The pro word is pan-pan. The visual signals are Morse code signals XXX. The sound signals are Morse code XXX. Any aircraft that is in any form of difficulty that wishes to indicate by means other than RTF that it is compelled to land, but does not require any assistance, may use either of the following visual signals: repeated switching on and off of its landing lights, or repeated switching on and off of its navigation lights, so as to distinguish from normal flashing operation. The following are dedicated radio frequencies used to communicate distress, urgency, and safety messages. You are required to know these: VHF 121.5 MHz Aeronautical Mobile Emergency (VHF), UHF 243 MHz Aeronautical Mobile Emergency (UHF), mainly military, HF 2182 kHz International Maritime Distress and Calling HF, SAR SAT 406 MHz SAR beacon frequency, also 121.5. Each state has the right to restrict or prohibit flight into its territorial airspace for reasons of security or safety. Such areas are known as danger areas, restricted areas, or prohibited areas, and are detailed in the AIP. Areas that are not permanently closed off to airmen are notified by NOTAM when closed. By day or night, a series of projectiles discharged from the ground at intervals of 10 seconds, each showing red and green stars upon bursting, are used to warn aircraft that they are about to fly through or enter restricted, prohibited, or danger areas.